Good morning, everyone, and welcome to Day 2 of the Board of Registered Nursing Board meeting. Today is February 27th, 2025, and we will begin by taking roll call to establish a quorum. My name is Dolores Trujillo. I was appointed by Governor Newsom to serve in the direct care provider role, and I am the current president of the board. Vice President Neelu Patel.
Good morning. My name is Neelu Patel, and I was appointed by Governor Newsom in the advanced practice role, and I'm currently serving as the vice president of the board.
Thank you. Board member Jovita Dominguez.
Good morning, Jovita Dominguez, appointed by Governor Newsom in the Education and Licensing
Thank you.
Chair.
Board member Patricia Nguyen.
Hi, good morning, everyone. My name is Tricia Nguyen. I was appointed by Governor Newsom in a public member role.
Thank you. Board member David Lawler.
Good morning, David Lawler, also appointed by Governor Newsom in the public member role.
Thank you. Board member Vicky Granowitz.
Vicky Granowitz, public member appointed originally by Senator Tony Atkins.
And board member Allison Cormack.
Good morning. My name is Allison Cormack. I'm a public member and I was appointed by the Speaker of the Assembly.
Our executive officer, Loretta Melby.
Thank you. I'm Loretta Melby, or Lori, and I'm the board's executive officer appointed by the board.
And our board counsel, Reza Pejjuhesh.
Good morning, everyone. Reza Pejjuhesh, BRN Legal Counsel.
Thank you, everyone. Our quorum has been established for today's meeting.
Okay, consistent with what is on the agenda this morning, it says that the board will complete any items that were not completed from yesterday's agenda. And we do have some remaining cases to discuss in closed session. So at this point, we do anticipate it being probably about an hour. We will go into closed session and we are anticipating opening into open session to begin today's agenda, starting with legislation at approximately 10 o'clock. We will keep the board moderator updated. We will update that time if that changes, and there will be a slideshow up for the public who want to attend in open session. So at this point, we will close and go into closed session, and we'll reopen in open session. We're anticipating about 10 o'clock. Thank you guys for your patience. We are back. Our board president will open up in open session and we will establish a quorum and we'll move on to item 4.0.
Good morning, everyone. We will take roll call to establish our quorum. My name is Dolores Trujillo, present. Vice President Neelu Patel.
Patel, present.
Board member Jovita Dominguez.
Jovita Dominguez, present.
Board member Patricia Nguyen.
Present.
Board member David Lawler.
Lawler present.
Board member Vicky Granowitz.
Granowitz, present.
And board member Allison Cormack.
Cormack, present.
Our board executive officer, Loretta Melby.
I am present. Thank you.
And our board counsel, Reza Pejjuhesh.
This is Reza, present.
Thank you. Quorum has been established. We will begin our open session with the next agenda item.
Okay, so we'll be going into agenda item 4.0. This is report on legislation, and Marissa Clark, the chief of legislation, is at the public table.
Good morning, everyone. I'm Marissa Clark, Chief of Legislative Affairs. So we only have 4 bills on the agenda today. I just wanted to kind of make note of where we are in the session and why it's a smaller list right now. Every year we kind of do the scheduling dance because we have to meet every 3 months. So we typically meet in November, which puts our next meeting in February. However, end of February is also the bill introduction deadline. So typically it's around the 3rd week of February. This year is pushed out a week. And so since we have Bagley-Keene, which we have to post the agenda 10 days in advance, it always puts us kind of like trying to struggle with getting all the bills we can, but also meeting our, requirements under Bagley-Keene. So this year, the bill introduction deadline was a week after our Bagley-Keene posting. So there was a number of other bills that were introduced. They'll be discussed at the next meeting, but I just wanted to give some context for why there is kind of a smaller amount right now. But you may hear of other bills that have been introduced. They just, unfortunately, we didn't get them in time to put them and meet that 10-day notice. So these were ones that were introduced earlier. So the first one is AB 346 by Assemblymember Nguyen. This bill would make changes related to California's In-Home Support Services Program, also known as IHSS. IHSS is a Medi-Cal program that provides in-home assistance to seniors and individuals with disabilities as an alternative to them receiving out-of-home care. The IHSS program provides personal care services such as dressing, bathing, feeding, cleaning, shopping, cooking, etc. But it also provides paramedical services, so things such as help with injections, wound care, colostomy, and catheter care. And so current law requires that paramedical services must be provided under the direction of a licensed healthcare professional. This bill would essentially just kind of clarify that when using the term licensed healthcare professional, it has the same definition as the term healthcare practitioner, as is defined in Business and Professions Code 680. And Business and Professions Code 680 defines the term healthcare practitioner as any person who engages in acts that are subject of licensure or regulation under BPC Code Division 2, the healing arts area. So that would include us as well as all the other healing arts boards and their licensees. Current law also requires that to receive IHSS services, a licensed healthcare professional must certify that the individual is unable to perform some activity of daily living independently, and that without those services, the individual would be at risk of placement in out-of-home care. So as of right now in the law, the phrase licensed healthcare professional includes all of the following professions: a physician assistant, a regional center clinician or clinician supervisor, an occupational therapist, a physical therapist, a psychiatrist, a psychologist, an optometrist, an ophthalmologist, or a public health nurse. So this bill would expand upon that list to also include of the professionals that can certify eligibility for IHSS to have a nurse or a nurse practitioner who is working under the direction of a licensed healthcare professional. And so just an additional kind of consideration when it comes to that language, while an RN or standard RN obviously would require supervision, we do have our 103s and 104s that are able to perform these types of duties without supervision, just as some context. So happy to answer any questions.
Thank you, Marissa. The certification for these individuals, how would they obtain that certification?
My understanding is there's a standard form that is provided, I believe by Public Health or Healthcare Services. I can't remember which department administers it. And so they fill out certain information, and then there's certain professions that are eligible to sign that form. And so this would add within our code a nurse or an NP to the eligible signing entities.
And would the board be involved in this in any way?
Not that I'm aware of.
Yeah.
No.
Okay.
So then would the licensed professional be responsible for any issues that result with the patient if harm was done?
I believe they would by providing that care. I think there's kind of two facets of it. One, certifying the eligibility for the care, and then two, providing the care. And so I think whoever is providing that care obviously would take on that liability, but then it may be an instance, and Laura, please correct me if I'm wrong, where maybe an NP could certify they're eligible because they meet that criteria, but then another type of healthcare practitioner could actually be the one in-home providing the care.
Okay.
Correct. So this is currently done through CARES Act from COVID, and it's something that's been in practice. So what happens is this is just kind of codifying and making it a permanent process so that nurse practitioners can do this. There's on page 4 of your materials, it says healthcare certification form. That's the form. If you clicked on it, you could see how you fill that out and turn that in. And then the CARES Act that I just referenced of 2020 is immediately below that on page 5. And that was the modality that they were using prior to this. So this is not new. This is just codifying what happened there as a temporary fix and making it a permanent fix.
All right. Any other questions or comments from board members? No? I would like to make a motion to watch this bill. Thank you. BRN moderator, please open us up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, it doesn't appear we do.
Thank you. Would you like me to close this window?
Yes, thank you. Okay, we'll take it to a vote. Trujillo votes yes. Vice President Neela Patel,
Patel, yes.
Board Member Jovita Dominguez,
Jovita Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member David Lawler,
Lawler, yes.
Board Member Vicky Granowitz,
Vicky Granowitz, yes.
and Board Member Allison Cormack.
Yes.
Thank you.
Okay, so the next bill is AB 479 by Assemblymember Tengipa. And this bill idea was actually brought forward by the board. It has been discussed at the Nurse Practice Committee as well as through the Admin Committee. Just for some background to kind of give context to the changes that are being sought. Back in 2021, there was a bill, AB 124, that was signed into law. And this bill allows a person who was arrested for or convicted of a nonviolent offense while they were a victim of intimate partner violence or sexual violence to petition the court under penalty of perjury for vacator relief, so a relief of their conviction potentially. So to receive this relief, the petitioner has to establish using clear and convincing evidence that the arrest or conviction was a direct result of them being a victim of intimate partner violence or sexual violence. And so this bill actually expanded upon previous legislation that had provided a petition option to victims of human trafficking who had potentially committed crimes while they were in the process of being trafficked. So if a court does grant a petition under AB 124, the code section that it added is Penal Code Section 236.15. The conviction is dismissed and deemed to have never occurred. So this additionally means that the records of the crimes are sealed, destroyed, and cannot be distributed to a licensing board. This is in statute, such as the BRN for purposes of license discipline. So kind of broadly speaking, fantastic policy intent around the bill. However, last year, the BRN encountered a situation that indicated there may be need for some minor amendments to the current language. So just high level, last year there was a board licensee who was convicted, unfortunately, of possessing child pornography. And as a result, the board filed an accusation to revoke their license. While the board was awaiting hearing before the administrative court regarding the accusation, the licensee then petitioned the trial court to vacate their conviction under the provisions of Penal Code Section 236.15, which was added by AB 124. However, the board was never made aware that this petition had been filed, so we were not able to provide the trial court with any type of input or feedback related to the licensee's role as a healthcare provider for their consideration when determining the petition. And so the trial court did ultimately grant the petition to vacate the licensee's conviction, which then, as I indicated, sealed all the records and therefore prohibited the board from using the conviction or any related records to continue pursuing any type of discipline in the administrative court. So in an attempt to try and avoid the situation in the future, AB 479 would require that if a licensee is arrested for or convicted of a nonviolent offense and files a petition for relief under Penal Code Section 236.15, the applicable licensing body is provided an opportunity to respond to the petition if it wishes to do so. So it's not mandatory. It's only if the board feels like there's going to be a reason for them to come forward. The bill would also require that if a petitioner holds a professional license and their offense is substantially related to the qualifications, functions, or duties of their role as a licensee, the court shall consider and make findings regarding the impact on the public health, safety, and welfare in its evaluation of the petition. So the bill is not intended in any way to kind of interfere or override with the discretion that the courts were granted by AB 24, rather just provide an opportunity that if appropriate, the board to give the court some input for them to consider as part of their broader argument when they're considering that petition before they make their final ruling. So happy to answer any questions on this.
Any questions or comments from board members? No? All right, I would like to make a motion to support this bill.
I'll second.
So,
David.
Patel, seconds.
Thank you. BRN moderator, will you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Lori NP would like to make a comment. 1 second, please.
I can understand why everybody would support this. But as an NP that has been involved in the disciplinary process, I would like to say that I feel like I was arrested. I was not convicted of a crime, but the BRN has all of that information and has used that all against me. The law, the criminal court system has not punished me. That is all clear. The only entity that is a problem is the BRN. And I have to say that now that's not just California, that's the entire United States because of the NPI number and just the fact that I am a nurse practitioner. If I would have decided to work as an RN in my field instead of an NP, I would not have the National Provider Data Bank after me. I started probation at the point that I was having a medical procedure and I was not going to be able to do probation. That is an ADA complaint. I was told just surrender your license and then you can come back in a year and then you can start probation again. I was never discussed with NPI number and the National Provider Database. So this right here makes it so that if and when my crime is ever taken care of, that you guys want to go back in. This is a mental health, like living type of thing. Thank you for letting me comment. Thank you for considering this.
Thank you. And
Thank
just
you
to
for your
provide
comment.
clarification to the public commenter, this bill that is on the table right now does not have anything to do with our intervention program or our probation program. So to be clear, this does not allow for any opening back up or anything at that point. So just so that people are aware that that does not have the effect that is assumed by the public commenter. Thank you.
Thank you. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, it doesn't appear that we do.
Thank you. Would you like me to close this window?
Yes, please. All right, we have a motion and a second on the floor. We will do roll call to do the vote. Dolores Trujillo votes yes. Vice President Neela Patel.
Patel, yes.
Board Member Jovita Dominguez.
Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
Board Member Vicki Granowitz.
Granowitz, yes.
And Board Member Allison Cormack.
Cormac, yes.
Thank you.
Thank you. So the next bill is AB 489 by Assemblymember Bonta. And under current law, there's a prohibition against any person or persons not licensed or certified by the BRN from impersonating a professional nurse or pretending to be a licensed to practice professional nursing. This includes using identifying phrases such as registered nurse or RN. And there are several other healing arts boards under the DCA umbrella that have very similar kind of prohibitions related to misrepresentation for their profession. So what this bill would do is it would prohibit an entity who develops or deploys AI technology from using specified terms, letters, or phrases to indicate or imply possession of a license or certificate to practice a healthcare profession without having the appropriate license or certificate. The bill would establish that the use of a term, letter, or phrase in the advertising or functionality of an AI system, program, device, or similar technology that indicates or implies that the care or advice being offered through the AI technology is actually being offered by a natural person that is in possession of the appropriate license or certification is prohibited. And then lastly, the bill states that each use of a prohibited term, letter, or phrase shall constitute a separate violation, and that a violation is subject to the jurisdiction of the appropriate healthcare professional licensing board or enforcement agency. So just some additional considerations when it comes to that last clause. For purposes of RN misrepresentation, if a licensee were to violate this provision, say if a licensee had their own kind of practice and was utilizing an AI platform that was misrepresenting itself, the platform itself as an RN, we would be able to take action because they are a licensee against them. However, if it's a broader company or healthcare entity that violates the provisions of this law, it is unclear what level of action, if any, the board could take based on that violation under our current provisions. So that is something we have shared with the sponsors and is kind of being discussed, but I wanted to provide it as context for you all.
All right.
One additional addition to that is we do have a provision in our business profession code, excuse me, NPA, that references a penal code section that says we can take action on unlicensed people that impersonate an RN. However, in the reality of bringing that to fruition, that's not something that we've ever been able to do. And so that is something to consider as well. If somebody that is not licensed, that is not a healthcare agency, utilizes a system that uses AI that holds themselves out as a licensee, an RN or anything like that, we don't have the ability to take any action on that either, even though this bill references for us to take action. So there is some work that needs to be done on that as well. So we would only be able to take action possibly on a licensee, but not someone that's not a licensee that would impersonate, and not a healthcare agency or any other company that utilizes it that impersonates.
And to clarify, the bill does say the appropriate healthcare licensing board or appropriate enforcement agency. It doesn't specify what that agency is or how kind of which ones are determined and taken by who, but it does kind of offer that second option, which, as we described, for depending on the violation, it would need to go potentially different routes.
Board Member Patricia Nguyen.
Thanks very much, and thanks, Marissa. So what would be a logical enforcement agency?
My, just off the top of my guess, would be the Attorney General's office.
Okay.
To enforce things like this. I'm not as well versed in the kind of up and coming AI type of situations, but that would be my kind of first thought. But it is something, like I said, we did bring up to the sponsor, and there is a kind of another conversation that's going to happen cross boards around this bill and potential ideas. So I'm sure there'll be some.
Can I do a quick follow-up to Reza? So Reza, so the Attorney General acts as our attorney when requested. So is this the kind of thing, I mean, we don't have authority, but is this the kind of thing we would request the AG to look into? Or is it like completely different jurisdiction?
You're saying, would we
If we see somebody that's an
be
impersonator,
the ones primarily responsible for directing the AG to prosecute these? Is that what you're asking?
yeah, kind of.
It doesn't seem that way.
Okay.
I'm sure, like anything, if something were referred to us indicating a possible violation of this, we would refer it to the appropriate entity, which would be the AG.
Okay.
So I did meet with the AGs and kind of talked about the unlicensed aspect of this. And they even said that even if we brought it to them, there's really nothing they would have to be able to stand on it. So it's not implementable in a way that would allow us to take action in its current form.
So that would be, we would not have a role, but somebody out there might have a role.
If it was criminal, then potentially, but any non-criminal action, we wouldn't have the ability to do anything like that.
Board Member Patel here. Marissa, I was just wondering if you happen to know, are we waiting on amendments that might come into play as they're working this out?
I don't know if they're in the works, but I do know this is something that it is the very first iteration of it. It's very early in the session. So I think what is going to come is probably going to be something a little bit different down the road, but just that we have communicated this to the sponsor and they understood. And I think there's going to be more conversation. So I wouldn't count this as being the final version of the bill.
Then I think we should probably make a motion to watch this bill for now. Do you have a second?
I was going to make a motion to support.
So if there's a second to watch, because that was the motion that was made first, then we would move forward with that and then take a vote. And if it fails, then we would go to the motion to support. And if that had a second, then we can go to a motion of support and then.
I'd second the watch just because I would like to see how this plays out. I'm supportive of the concept, absolutely, but I'm not in favor of passing a bill or supporting a bill where there's kind of no real enforcement mechanism. I would love to see an enforcement mechanism.
Marissa, can you explain on if that limits our ability on having conversations with the author? If we're just watching, do we have an ability to make suggestions? Like if they were to take a position of support with amends, right?
Yeah.
So if they took a position with the support with amendments, then we would be able to propose those amendments, which would be addressing the ability to say, we need an enforcement. We need a section in here that's enforcement related to BRN. If they take a watch position, we can't do that. Is that accurate?
So if we, as with any bills you've explained before, we can always provide technical assistance. So anytime a sponsor or an author reaches out and said, you know, if this bill were to be implemented tomorrow, what are your concerns? What are the barriers? What are not indicating any type of direction from the members that you hadn't taken. Because if you take a watch, you're not indicating a support or an oppose. So we can still provide any technical assistance they request from us. If it was a support, if amended, essentially means that we are leaning towards that support. However, if you take these specific changes, we will be a strong support, and it gives kind of the proactive reach out. So conversations around implementation concerns can happen either way. One is just indicating your general feel about the bill, which I can't state on your behalf unless you've shared it, if that helps.
I guess what I'm reading here is there's a sentence for me that sums it all up. And it's AB 489 will ensure that generative AI is not used dishonestly or negligently to confuse and mislead California consumers. And that summed it up for me to support this. If there are amends or changes to the bill, it will come back to the board, correct? And we can change our position at that point if we feel that the amendments do not support what we initially envisioned from this bill, correct?
And you could do a support with amends.
And we
So
could
that
do
you
a
want to
support with
address the
amends.
Enforcement issue. So on the table first was a watch position. So we have a first on a watch. Do we have a second on a watch?
I did, but I'm willing to withdraw my second if.
I'm willing to withdraw my first.
Okay. So then,
I'll second,
hang on a second, hang on. So do we have a support or a support with amends is what Dolores is making? I just want to make sure.
Support with amends is fine.
Okay. So there's a motion on the table for support with amends. Do we have a second?
I second David.
David seconds. Okay.
Okay.
Now,
Any
go ahead.
other questions or discussion from board members?
Well,
ahead,
I would just say that our amendment would be with an enforcement mechanism, an effective enforcement mechanism.
To clarify enforcement, okay.
Allison and Vicky, do you have any comments that you'd like to contribute to this? No? All right. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Matt Liege would like to make a comment. 1 second, please.
This is Matt Leger on behalf of SEIU. We're the sponsor of AB 489. So really appreciate the conversation today and the early conversation with the executive director and board staff on this bill. I think the conversation has really highlighted where we are at in the process. We, as the sponsor, we want to make sure that if someone is representing themselves as a licensee holder, that means they actually went through the training, education, and have the expertise and pass the test. And so that's the sort of fundamental goal of the bill, and look forward to pushing that forward, and definitely very open to the continued collaboration around making sure the enforcement process works. So thank you very much for your consideration, and we appreciate the support.
Thank you for your comment. Catherine Hughes would like to make a comment. 1 second, please.
Nurse and Executive Director of the Nurse Alliance of SEIU California. Just want to echo Matt Leger with SEIU California and thank the board for their motion to support with amendments. I think that we really appreciate that. Thank you so much, and we look forward to working with you.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments there in your location?
Doesn't appear to be so. So we're fine with closing and taking a vote.
Thank you.
All right. We have a motion on the floor with a second. We'll take it to a vote. Dolores Trujillo votes yes. Vice President Neelu Patel.
Patel, yes.
Board Member Jovita Dominguez.
Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
Board Member Vicki Granowitz.
Granowitz, yes.
And Board Member Allison Cormack.
Cormack, yes.
Thank you.
Okay, so the last bill is AB 583 by Assemblymember Pellerin. And this is kind of similar nature to the first bill in that it's kind of just expanding a function or proposing to expand a function that's already done by certain healthcare providers to include NPs. But in this one, it has to do with death certificates. So current law states that on a death certificate, the medical and health section and the time of death shall be completed and attested to by the physician and surgeon last in attendance. Current law also states that in case of a patient in a skilled nursing or intermediate care facility at the time of death, that information shall be completed by the physician and surgeon last in attendance or by a licensed physician assistant under the supervision of the physician and surgeon last in attendance, if the physician and surgeon or licensed physician assistant is authorized to certify and attest to these facts, and if the physician assistant has visited the patient within 72 hours of the death. So this bill would expand upon that second provision related to patients in a skilled nursing or intermediate care facility to also allow for the medical and health section and time of death to be completed by a licensed nurse practitioner, and then make other kind of conforming changes related to extending that authorization of that function to an NP. Current law also states that a physician and surgeon, physician assistant, funeral director, or other person must immediately notify the coroner when they have knowledge of a death that occurred or has charge of a body in which a death occurred under certain specified circumstances that are outlined in the Health and Safety Code. These include that a death occurred without medical attendance, during potentially continued absence of a physician and surgeon, where the attending physician and surgeon was unable to state the cause of death, where suicide is suspected following an injury or an accident, or under circumstances that could lead it to suspect the death was caused by a criminal act. So similarly, this bill would propose to extend that provision, stating that both a physician and surgeon, a physician assistant, a funeral director, and a licensed a licensed NP or nurse practitioner would be required to notify the coroner of a death that occurred under these specified circumstances. So again, just kind of expanding existing functions that are being delivered by physicians or physician assistants to also authorize nurse practitioners to perform them.
Any questions or comments from board members? I would like to make a motion to support.
I'll second.
Thank you. BRN moderator, please open us up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Amy Paulson would like to make a comment. 1 second, please.
Thank you. We really appreciate the ability to support the families of our patients. And CAMP would really like for this bill to ensure that the 103 and 104 NPs can be in the attendance of their own patients and they're not required to be supervised. In addition to that, in the event an NP works with a physician in the same office where there is a patient death and a need for a certification signature, we also are wanting to ensure that that NP can sign on behalf of their physician colleague when needed. So thank you very much for this opportunity.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, it doesn't appear that we do.
Thank you. Would you like me to close this window?
Yes, thank you.
You.
All right, we have a motion and a second on the floor. We'll take it to a vote. Dolores Trujillo votes yes. Vice President Neela Patel.
Patel, yes.
Board Member Jovita Dominguez.
Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
Board Member Vicky Granowitz.
Granowitz, yes.
And Board Member Allison Cormack.
Cormack, yes.
Thank you. I believe that wraps up our ledge portion of the agenda.
Kind of. So
Kind
it
of.
is part of the agenda, but I did want to make sure that our board members were aware that because it is early in the session, depending on the bills that come in, we may end up holding another board meeting prior to May if that becomes an issue where we do have to take positions, because there were bills that were introduced that repeats from last year that we had opposed. And so we may be required to come in and do another board meeting. So I just wanted to make sure that everybody was kind of aware of that as a scheduling process. Yes.
Would that meeting have to be in person?
It would, yeah, which is why I wanted to let you guys know in advance. So as Marissa had said, kind of opening up, that there were many bills introduced after our agenda deadline. And so as Marissa continues to mull through each one of those bills, if there becomes a need that is identified where we would have to have a board meeting prior to May, because in May, it's already gone through the first house and maybe the second.
Yeah, so by the time the May meeting, this is again, the calendars are very tricky early in the year, is the policy committees in the first house, which is really the platform for stakeholders, ourselves included, to weigh in on bills, to both file a letter kind of in written, but also go in person and testify. Those are predominantly done in March and April. And so by May is when you're kind of moving into the fiscal committee. And so you still have a little bit, and then you can get into the second house. But that first policy committee is where kind of the meaty discussion around a bill's policy merits happens. So it puts us in a tricky spot when we're kind of February and then May, because Yeah, that helps.
And so there are authors that purposely introduce after our agenda deadline so that we don't get a position on it and so that we can't show up in hearing and oppose. So that is something that we're very aware of. So we may need to hold an additional board meeting in March so that we can get that movement in and we can come in and show up in hearing. The other thing that we are looking at, just so we can plan for next year, is we are planning our board meeting to be as late into November as possible. So we may have to change some dates or move it into like the first week of December and just kind of push that so that we can have a board meeting in March. So what we're trying to do with our schedule, because we are held to an every 3-month board meeting, what we're trying to do is have a committee meeting in February instead of January so that we can have a board meeting in March next year. So that will set our new calendar going forward. So we won't be in this position anymore. So this will be the last year that we would have to manage that bill introduction deadline. And so we plan to be kind of dark in January and then go in. So there will be a little changes to our board meetings this year. So I'm asking our board members to be pretty flexible with that. And then fully anticipate that we will probably need to do a not regularly scheduled board meeting, but a board meeting noticed for March if we can coordinate a time. So we'll start working with you guys on that so that we can address some of the bills that were introduced after our agenda deadline.
Thank you, Lori. This is item 5.0. This is the report of the Enforcement, Investigation, and Intervention Committee. And this is chaired by Patricia Nguyen.
Thank you very much. So we'll move to item 5.1. You'll all remember that in August of 2024, the board made a motion which directed our executive officer to provide an update to the EIIC regarding the intervention program participants who were having problems with kind of just not getting through the intervention program. So Loretta Melby, has been on top of that, and she's going to report out on what she has found to date. So thank you very much, Lori. I'm turning it over to you.
Thank you. So 5.0 is just really to kind of keep the board apprised of all of the reviews and processes that's been going on since we did receive that motion in August. So with that, I did just want to give out some reports that we have now entered into the contract with Premier. They did start in January. Maximus did end their contract at the end of December. And so since our last board meeting was in November, you guys were hearing that Maximus was coming out and that we were actively pursuing a contract through DCA and that we had secured Premier Health, and they are now, that transition has completed. Needless to say, it is a huge learning curve, but the one thing that I really do appreciate about Premier is that they are a substance use disorder, mental health, healthcare organization. So they have a lot of history and practice in this. And with the direction and assistance from BRN staff, they are learning quickly, and we are able to move forward and kind of continue to assist the participants. I do, of course, welcome any reach outs from participants or anybody that's struggling with that. If we don't know about it, we can't address it. So they are very willing to jump in and do whatever is needed to do to make this as seamless as possible. But we know that any change, there's going to be some difficulties. From the August board motion data, starting on page 5, they do have reviews sent to the EO, and that is 30. And of those that I approved were 7, and 23 were re-reviewed back to the IEC committee. To be clear on what the role is for myself as the executive officer in this, based on that board motion, is not for me to change the IEC recommendation, but to review the IEC recommendation, make sure that it fits the outlines that were given by our board and that there is evidence to support that. So you will see that I have definitely kicked them back to IEC, not because I disagreed with them, but because we needed evidence to support that. And so there are a couple participants that are caught in a loop right now, which is why we've added the agenda item 5.5 to have further discussion about that so that we can offer some more assistance, because right now we're just kind of reviewing and kicking them back and then reviewing and kicking them back. A couple examples were that some had come forward in August and they're still kind of, no, you need to go back to IEC and get re-reviewed. So with that, you can see that there are some data here for you guys to review. Overall, it is going well. So it is a positive movement in the right direction, I do believe, with this. And the stuff that is coming back in front of me for re-review is coming forward with much more documentation, much more support, and very clear in what the ask is. Additionally, I've been seeing less reviews coming to me, which means that the review process and recommendations from IECs are meeting the guidelines of that BRN board meeting motion, and they're not having to come forward for review. So that is exciting for me to see, as well as that review process diminishes in there. So that is the data that is in front of you. I don't know if you guys have any specific questions on that, but I am available to answer.
Well, before we open it up for questions, I just want to thank you so much. I know that you're a busy person and you've been busier because of this assignment, but the numbers do show that we're heading in the right direction. And I know it's still early days, but I just really want to thank you very much for this additional work. And with that, I'll open it up to board members for questions or comments. How about Board Member Granowitz or Board Member Cormack?
I don't think I have anything, except it really is going in the right direction. I'll be interested in public comment to see how the public feels about it. And if we hear crickets, we'll know we're doing a better job.
I don't think we'll hear crickets.
I
Just
don't
because
either.
Yeah, as I shared in the report out, there are some issues that still need to be addressed, which is why we did do 5.5. And so if it is comments around being required to work in direct patient care, comments around being required to pass narcotics, that's more what this agenda item is specific to. And I believe we have solved the majority of that. The 5.5 agenda item is more about the requirement to work. And so I think that's where we'll have to kind of really move our focus to as we review that process. And so I don't think we'll hear crickets, but I am interested in hearing the public comment and then seeing what we can do to assist that.
As am I. Thank you very much. And would board moderator please take us to public comment at this point?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board member and committee chair Granowitz, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
There does not appear to be any public comment. So
Thank you.
thank you very much. You can go ahead and close the public comment. Thank you.
Wait a minute here. Somebody snuck in here. That's not that. Lori, would you like to read that or should I read it?
I can read it. It says, I have a potential student who is a VN and has been convicted of a DWI. Does this preclude her from the NCLEX? And then it says, and. No, it does not preclude her from the NCLEX. In fact, as a RN program graduate, you petition to the board to meet the licensing requirements. And we give what's called an authorization to test. The authorization to test and the ability to take the NCLEX is not based on your criminal background or any kind of background issues. So you can test. What needs to be done after the NCLEX is taken is a determination of whether or not you're safe to license. And so at that point, we would do a review to look at the enforcement stuff. And then if it is clear, we can license you with a full license or license you with a probationary license. But it doesn't change the ability to take the test. That process there was cleaned up and addressed a few years ago because we wanted to make sure that the ability to test and get that knowledge out and do that within the first 3 months, which is the studies that are out there that says that's most successful, has done that. And just for clarification, it said the ability to take the NCLEX and RN licensure. So it's a VN to RN step up.
Thank you.
Sorry. Excuse me, Reza, just wanted to add something. I appreciate the clarification Lori just gave, a very good distinction that she made there. I just wanted to add that there was a bill some time ago, a few years, that was proposed that would have established a method for individuals, perhaps in that situation, to submit a request to a licensing board for evaluation of their criminal history and whether that would preclude them from licensure. That bill didn't pass, and there's nothing along those lines currently in place. So we don't have a process, unfortunately, to give somebody in advance of nursing school or in advance of taking the NCLEX a concrete opinion or an opinion at all of whether they ultimately will get licensed.
Yeah, if they meet the licensing, if they meet the educational requirements, they can be tested, but it does not guarantee a licensure.
One last thing I'll add is for, speaking generally, not necessarily to that particular situation, but folks who might be concerned knowing that we don't have a process to opine on your licensability in advance, might want to look at the disciplinary guidelines and things like that, our regulations, which outline criteria for, quote, rehabilitation. So that's something that's looked at if criminal history potentially would be a barrier to licensure. Rehabilitative efforts potentially go a long way to, still allow somebody to get licensed.
Wonderful. And then just for further information, our contact information is on our web. So if you do want to reach out and have specific questions, you're always welcome to email me. There is under executive leadership, there's also staff emails, and you can reach out directly to enforcement as well. Thank you.
Perfect. Thank you. And she says thank you. With that, I'm going to close the window if that's okay.
Thank you very much.
Yes, and that was information only, so no motion, no vote needed. We can move on to agenda item 5.2.
Thank you very much. And this is the Enforcement Division update, and I'm not exactly good. Hi, Tim. Thank you.
Yeah.
Good. Thank you very much.
Right. Good morning, everyone. My name is Tim Bunger, and I am the Deputy Chief over Discipline and Probation here at the board. I'm presenting today in place of our Enforcement Chief Shannon, who's on vacation, and Jaspreet, my peer Deputy Chief, as well. So getting into agenda item 5.2, the BRN does continue to participate in the NCSBN 5-year substance abuse study For alternative to discipline programs, the procedure or guidelines for those programs are that they are at least 3 years without a relapse. They have to check in daily, including holidays and weekends. They have to test at least 2 times per month, and that the times are random along with the types of test. They have to attend a structured support group at least 2 times per month, and then a mutual support group at least once per week. We also, as Lori mentioned in our other agenda item yesterday, we are always recruiting for expert practice consultants to review our cases. Currently, the areas that we're in the most need of qualified experts is long-term care, skilled nursing, geriatric, acute rehabilitation, school nursing, medical surgical, pediatric ICU, CCU and telemetry, and dialysis. So if anyone listening knows of any people that would be interested, please look at our website and submit an application, as we would be very grateful for your assistance. Our complaint intake unit continues to use the CPRG, which is the Complaint Prioritization and Referral Guidelines, to triage cases in collaboration with DFI and BRN Investigations. Our discipline unit currently has 13% of our cases over a year pending at the Attorney General's office. That is a little bit higher than it's been historically, but still fairly low. But we are always looking to keep that around the 10% mark. We are also working on enhancements to the BRN website for probation. And we're in the final stages of creating 2 different webcasts to be posted for the probation process overview, as well as worksite monitor role and responsibilities. One of the comments at the committee meeting was, kind of, this has been an agenda item pending for a while. What's the status? The presentations have been finalized, but now we're at the part of needing to reach out to DCA to get their help with actually making the webcast. So it is moving forward, and hopefully soon we'll have that posted. Going into the stats, a couple things I wanted to highlight. First is, and we did this for the committee meeting last month and then brought this forward to board, is we did a fiscal year to date comparison for the past 5 fiscal years. This isn't typically how we report data, but this was done because we missed putting the full fiscal year comparison back in like the August, September meeting. So this was our interim fix to kind of show a similar date range and pattern, so quarters 1 and 2. Unless asked, you probably won't see data presented like this. It'll go back to just the normal fiscal year to date for most meetings. The exception being in around the August, September meetings, those would be the full fiscal year to date or full fiscal year comparisons for the past 5 fiscal years. So this was kind of an interim point for that. But you'll see the more standard stuff going forward. There was a couple of things I wanted to point out as well. To clarify, on table C, which is page 12 of your packets, the pending board vote number, which for this last July 1st to December 31st was 52. That's not an aging number, that's a volume. And we discussed those in our presentation yesterday, but those are the cases that are at various stages of being voted on and then forwarding to be adopted. And then scrolling down to page 15, I did want to highlight on this table, and I believe the next one, that there was some data at the committee meeting that was identified as possibly not accurate, and to double check. And looking at this, we noticed that for July 1, 2020 to December 31st, 2020, and then the same for 21, the numbers are identical. That is accurate. They did actually match, which is kind of interesting. However, for 2024 numbers, those numbers are not correct. The updated numbers are the average days to complete was 744, so it went up about 80 days, and I'll explain that shortly. The greater than 540 days was 67%, and the under 540 was 33, about an 8% change from what was previously up there. I did want to talk about that because obviously that jump is a little bit concerning. Specifically, we had kind of a weird, not typical occurrence in quarter 2 of this past year. where we had a lower volume of cases closed, but they had a higher time in investigation. And I want to highlight that this wasn't tied to, BRN, DFI, investigation units, or complaint intake unit. I reviewed kind of the highest cases that were on there. All of them were moving. They just unfortunately took time. And with the lower volume of cases moving through and getting closed, it brought the numbers up. I don't suspect that we'll see that for the rest of the quarter, but we'll see. But it's kind of a weird, perfect storm of scenarios that played into that. But I wanted to make sure you had the accurate numbers. And then going next to table G on page 16, these numbers in the committee meeting last month were the ones that were questioned. They were incorrect. The updated numbers are the ones that are in your packet now. So for 2024, we had 467 cases with average time and intake of 6 days. Investigation was 373, pre-AG time 25, post-AG time 344, and then a cycle time of 747. And again, Q2 is what really brought that average up, but then the case volume being down is what did play a significant impact in the aging being higher on average. So with that, do you have any questions or comments for me?
Well, my comment to you is thank you very much for this report. It's very detailed. I also had just one specific question about on table B, which is page 11, July through December of 2023, we had a huge jump in the number of citations issued. Do you know if that coalesced around a certain set of facts, or was it just an anomaly?
Off the top of my head, I think it was an anomaly. I can look into it further and get back to you. I can't remember any big operation or cleanup that we did around them that would cause that spike.
Thanks very much,
I
Tim.
think I might remember.
Okay.
I think it was all the returned mail from the certificates that went out. So we received a large number of returned mail. And when we receive returned mail, we know that the address was not updated. And so we do a process where we issue a citation because they did not update the address of record within the 30 days. And so I believe that might be what that was referring to, as we did discover a stack of returned mail that we needed to address.
Thanks very much, Lori. Any other questions or comments from board members?
Not a board member, but I do have a question really quick. Because this is materials and this is something that's referenced back to Tim, I would ask that we update that table F with the current numbers, and we will note in red or something that it's been updated on the materials so that that is something that can be referenced back for longevity.
Thank you. Okay, go ahead.
I would just like to see that these numbers that were reported out, these comparison numbers, be an ongoing part of our board meetings from here out.
So I think they do report out, but they haven't done it in this 6-month increment. Would you rather have the 6-month increment? Yes, okay.
So 6-month increment or fiscal year to date?
Fiscal year to date.
So if you can do fiscal year to date, but ongoing comparison of the last 5 years.
Okay.
And then I did get a request to do line graphing to kind of add a visual, because not everybody tracks numbers and they may want to just see the dips and the peaks as well. So that has been a request for our enforcement investigation data to have that showing patterns.
That's what I would really like to see.
Great. Thanks very much.
Chairman, this is Board Member Cormack.
Board Member Cormack, please go ahead.
So much. So I spoke on this pretty extensively in the committee, and I'll just sum that up for now. First of all, thank you very much to the team for taking a look at the numbers, some of which were suspicious and some of which were correct. And that, I think, speaks to what, Board President Trujillo just mentioned, the importance of having this with the historical context. So I agree that this level of information is really useful to us and to the public, so we can identify what's a blip and and what's a problem that we need to spend time on. I guess one thing that's brought up to me by the recent comment from the EO is we do see people not updating their address of record, and we do a lot that is by mail. I just wonder, as the world goes towards these, devices, is texting people, is that something that we consider as an alternative? Would this require changes? It feels a little, I understand that it's formal and legal, but it feels a little old school. And I think occasionally people do miss an email because their spam filters aren't set correctly. So I don't know that this is exactly the right place, but I know this does appear to be an issue as the world changes. So I'll just throw that out for staff.
You're speaking my language, Allison. I hate that we do snail mail. However, in our statutory and regulatory language, it does say that we will notice them by mail. And so we would have to do either a regulatory update or ask for a legislative cleanup to address that. The other issue that we run into is that we have no authority over people's email addresses. That has not been added. That is a requirement. So we would either need to, again, do a regulatory update or ask in a legislative cleanup that we get email addresses for our licensees. And the text message one, I think I will die on this hill. I do want to be able to send text message notifications out. We don't have the technology to support that. I know that there is a board that was in contract to get a text messaging service. So I know that DCA is looking at that. I want to jump and join that as well. So we are seeing if they're able to secure that contract to be able to do text messaging notifications. If that does happen, we will then look at updating our regulations or asking for some kind of statutory cleanup so that we can utilize email addresses and text messaging notifications. Again, anytime someone comes from private sector like I did, it's kind of frustrating because I can't just update policy and procedure. I have to update reg or statute or ask for statute to be updated. So it does create kind of this black hole where you kind of think that you're kind of behind, and we are, but there's reasons for that, but we are looking at that to move forward. The other thing that we run into with emails is they will create an email specifically for BRN, and then they never check it because they never use that email again. Or they'll sign it up to an old work address and then they'll change jobs a couple times. So we do need to have the USPS way to notify people because that's kind of our most reliable method. But I do want to explore emails and text.
Great, thank you for that.
Any further board comment or question? Hearing none, would the board moderator please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board member and committee chair Granowitz, there are no public requests for comments on the WebEx. Do we have any in-person requests for comments in your location?
No, there do not appear to be any public comments in this location.
Thank you. Would you like me to close this window?
Yes, please. Thanks very much. Again, this was information only, so we're ready to move on to the next item. I see Nicole getting ready to come to the table. So this is information only, investigations divisions update. Division update. Thanks, Nicole.
Good afternoon. Can you guys hear me okay? Okay. My name is Nicole Bowles. I am the Deputy Chief of Investigations, and I will be giving the Investigations Division update. We continue to work with the Office of Organizational Improvement regarding our mapping and workflow to assess our timeframes and our procedures in order to streamline and improve our internal processes. The OAO team works with our subject matter experts in investigations from each unit and staffing level, and investigations will continue to report out on the progress of this project in the future meetings. On November 19th, 2024, the Board of Registered Nursing and the Office of Attorney General conducted the fourth of a four-part series. This series included topics on the administrative process, general nursing practice, unprofessional conduct, report writing, advanced practice nursing, records, evidence, medical spas, and nursing corporations. It was really great training. The Division of Investigations participated in this training with us, as well as the Enforcement Division. And we are anticipating that we conduct this training annually with our DAG liaisons. So we are grateful to them for providing that training to the Investigations Division, as well as Enforcement and the Division of Investigation. Investigations continues to adhere to recommendation number 7 of the 2016 audit by the California State Auditor. As Lori had touched on yesterday during that presentation, investigations is capped at a 30 caseload. As of February 12th, 2025, full-time special investigators have an average of 29 active cases each. And due to those high caseloads, the supervising special investigators and I continue to triage and actively work cases as well. Investigations received 185 cases in January 2025, which was a pretty stark increase from the 80 cases that we had received in December of 2024. We continue to explore multiple options to address these high caseloads, including recruitment of one full-time special investigator in the central region and limited term special investigators statewide. We have identified one candidate in the central region that we are going through the hiring process for, and we just recently onboarded a limited term special investigator in the southern region, so we are grateful for the additional help. Tim had already gone through the data, but if anybody has any questions on Table A on page 23 of your materials or on any of the information I shared, happy to answer those questions now.
Thanks very much. Nicole, I have a question. Just looking at the year-to-date for this past year, 2024, that was a huge jump in BRN cases referred. Also a great jump in cases completed. But I did wonder if, again, if this was a blip or, if there was one thing that happened that increased the cases so dramatically. I'd just love to hear your thoughts on that.
Like Tim stated, I would have to go back and take a look at it. I can't pinpoint right now on the spot if there was one specific incident or if it was just an anomaly.
Okay.
But I can do that research and get back to you.
Okay.
Okay.
Thank you.
No problem.
Did I see? Yeah, go ahead. Board Chair.
Hi, Nicole. Thank you for those numbers. Just a question about the cases that you're all carrying. You said the average was 29. That does include supervisors carrying cases also or not?
I'm sorry. No, the full-time special investigators are carrying an average of 29 cases.
Okay, so supervisors are not carrying, they don't carry any cases, or are they somehow absorbed into that number, or?
They're not absorbed into that number. I didn't report on the average caseload that I or the supervising special investigators are carrying. I can get that number for you, but it is much lower than the 29 because we still have our direct oversight responsibilities. So we carry a lower caseload, but with those cases that we carry, we are actively working the cases and also trying to triage. So the cases that we're triaging aren't essentially assigned to us. They're in the holding pattern. We review them as they're unassigned to ensure that with our level of expertise, is there something that we have identified that maybe this case would be more appropriate for the Division of Investigations to work rather than going to one of our special investigators? Could we have our investigations analysts do some additional triage work on some of these cases to determine if there's additional documents or information we could get before it goes to a special investigator to help alleviate that burden? The triaging of cases isn't included in that number. It would just be what is assigned for us to actually work through.
Got it. Because I thought I initially heard 30 yesterday, but I'm not quite sure now. So this 29 number, does that include your new hire also absorbing cases or not?
No, so
Okay.
when we onboard new staff, we start them with a much lower number to train them.
Makes sense.
I think it would be pretty intimidating to come onto a board and get 30 cases straight off of the bat, but we assign them a lower caseload just to get their feet wet and to start training them. They go out with our special investigators, our leads that we also have in the units, and 10 is where we're comfortable right now, but that's not to say that it couldn't increase because we have individuals come on to investigations with different backgrounds. We've had people come on with federal investigation background experience. We've had folks come from local police departments. We've had other folks come from state service doing investigations. So it really depends on their skill level and where we can start them and how quickly we can get them onboarded to take more cases.
Thank you. And I appreciate the work that you're all doing to complete these cases in a timely manner.
Thank you.
I wanted to make sure that I provided a little clarification on the supervising special investigator caseload. They don't have a caseload. That is not something that they should have. What they are doing is they are taking cases. So we would not have an average. And so when Nicole says, I don't have an average of what the supervising special investigators or she is taking, that is because that is not something that we try to continuously do. Because they do have other roles. Their role is not to do the investigations. Their role is to support the investigators and to provide, managerial oversight, et cetera. They do a lot of the case reviews and looking at them to kind of finalize cases, close them out, and like she had mentioned with the triages as well. What is different in this time frame is that they are taking cases, and Nicole is taking cases, and even our assistant executive officer is agreed to take cases if they have to come to her. And she is assisting in like just the triaging of that to help just kind of coordinate that. So it truly is right now an all hands on deck kind of process. For people that don't come from state service, again, a large learning curve for me is you kind of look at this and say, why don't you just hire more people? And God, that would be an amazing answer. That is not the way that state service works. And so we do have to recruit. They have recruited, they are hiring. When in our presentation that we gave yesterday, Yvonne gave some data, like these are our authorized positions, and then we have blanket and limited term. And so if we continue to have money available, then we could pursue a position that is not kind of authorized to us. And so we can do a blanket position or a limited term position. And so that is why we even have one limited term position that we're looking for right here. The other process that comes is if we do identify that we have ongoing numbers that we will need to address, we can ask for position authority and or the funding authority for that too. And I know that's not the correct statement right there. But what happens with that is we have to write a proposal that goes in front of the legislative body to say, yes, you can have another person, you can have another position. So thank you, expenditure authority. Yvonne just came to my back because she's fabulous. You know, I said yesterday, right hand and left hand man, she does it all. And so with that, we are looking at submitting a concept paper to get a budget change proposal to ask for more assistance in investigations. That doesn't mean we'll get it. That means we've identified a need. We have data support that there's a need, but we still have to ask permission for that. And so just so that everybody is fully aware of it, as we see our numbers increasing, we see these timelines increasing, we see our caseloads increasing for each one. We are very much aware of it. We're bringing it and being very transparent to our board and kind of airing this out in a very public manner, just to make sure that people know that it's not something that we're trying to keep under cover. And we are really exploring all avenues that we can. I did have a meeting with DCA and director and deputy director to say, are we missing something? Is there something more that we can do? And they're talking to other healing art boards. We have asked for a brainstorming session, maybe to come from other healing art boards as well, just to see if there's anything that we're not doing that we could be doing, because our caseloads are increasing and our numbers are increasing. So we want to get on top of that.
Thank you very much, Lori. Any other questions or comments from board members? How about our board members online? Any questions or comments? Okay, hearing none, would the board moderator please open us up for public comment?
Before we go out to public comment really quick, board president had a question. And what she was asking is how long can we keep the limited term positions? We petitioned to keep those as long as we have funding available for them. And we can't guarantee that we'll have funding with them. And it is a process to go through. And Yvonne is pointing, she wants to come up and steal the show.
I just wanted to state that any position in the blanket at any point in time can be eliminated by the Department of Finance. So those, even if it was a 2-year limited term expenditure or position authority, because we can get one or both, that position, because it is considered a blanket position, can be, the state term is swept. Sorry, we always would like the permanent position and expenditure authority. But there's fiscal concerns, there's lots of factors that go into that.
And one of the issues as well with the limited term is when we advertise for a limited term, you don't get really good qualified candidates because they want a permanent position. And so that becomes problematic as too. Yvonne did ask also to explain the 30 number of the CSA limit. Do you want to do that since you're up here now?
Yes, Dolores, you had mentioned hearing the 30 number yesterday, and I just wanted to explain that that is the number that is in our CSA audit. Originally, during the audit of 2016, it was given as 20. We worked with our internal audits with DCA and had that number increased to 30. And right now, our investigators, the full-time non-probationary investigators are at 29. So we don't have a lot of room to assign new cases because we cannot assign more than 30. And the thing that is really important is, and that's why probationary employees and other employees, if they're part-time, we only assign the number that they can actively work. Because if you're assigned a case and you're never going to be able to actively working it,
Okay.
that assignment is not valid.
Thank you, Yvonne.
Board moderator, you can open up to public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Lori NP would like to make a comment. 1 second, please.
Thank you. My question and comment is, does any of this kind of panic or, increased caseload have anything to do with the pausing of the pilot? And I put that in quotes. It seems like we kept extending this DOI pilot, and there was a pause of this pilot for a period of time. The pilot just seems odd. And do any of these numbers correlate with this pilot? Because the pilot project just seems so odd, and it was paused, and it just seems like all these things are changing suddenly.
So I can
Thank you,
provide
Todd.
some background to that, and Nicole, you can jump into if you need to correct me in any way. The pilot project that was done with a Division of Investigations had gone on for many years. So it was kind of more of a routine than a pilot. And so as they were doing that, and we would renew this through the Department of Consumer Affairs on an annual basis every December, what had happened towards the end of this last year is D of I had caseloads increasing and we had caseloads increasing. And so we had asked if we could pause. And the reason that BRN asked for the pause is it allowed for more cases to go to D of I. So we were able to work some of our cases, bring our caseloads down, and D of I came in to help. So it was not an anomaly. It wasn't odd. It was actually a very collaborative, wonderful agreement where they came in to assist us. Because the pilot went so well, they actually stopped the pilot because they made it permanent. And so that is where in Nicole's report yesterday out, where she was kind of talking about the CPRGs, that is part of that pilot becoming a permanent process. And that happened, I believe, February of 2024. March of 2024. Thank you. And so at that point, there is no more pilot because that pilot is permanent. And that is where we have the CPRGs. Now, to answer the question, do these numbers have any effect from that pause of the pilot or the termination of the pilot? Possibly. It is still very new in this. We do think that it does have an effect because less cases are going to the Division of Investigation and more cases are staying at BRN. But we don't have enough data to affirmatively say either way yet.
Can I just add to that really quickly? I think I'd stated this in our EIIC committee meeting, but we also can't predict how many cases we're going to be getting. And, you know, there are peaks and valleys to complaints being filed with the board and the cases that get referred over to investigation. So there may not be one catalyst cause to when we see an increase in public complaints that come through and then the increase that comes to the investigations division. So I just wanted to restate that. Thank you.
Thank you for your comment. Board Member Committee Chair Nguyen, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Thank you very much. So that was an information item only, so we do not need to take action. I'm going to turn it over to Lori right
Yes,
now.
please.
For logistics.
So we do know that we do have a couple more agenda items pending, but we will have to take lunch. And so we will break for lunch now, starting at 12 o'clock and return at 12:45. Does that sound right? Okay. So we will be back in here at 12:45 to open back up into open session, establish quorum, and complete the remainder of the agenda for today. Thank you guys so much. It is 12:45. We're going to open back up. I'm going to turn this over to our board president to establish quorum.
Okay, well, the committee chair is going to take roll. Thank you very much. President Trujillo,
Present.
Vice President Patel,
Patel present.
Board Member Dominguez,
Dominguez present.
Board Member Lawler,
Lawler present.
Board Member Cormack,
Cormack present.
Board Member Granowitz,
Granowitz present.
Board Member Nguyen present. Okay, we have a quorum. We're going to open agenda item number 5.4, information only intervention division update. And I'm going to turn it over to Lori.
Thank you. So 5.4 intervention update. I will be giving this update with Tim. So I'm going to let Tim open it up and then I'll add to it as it goes along.
Hello again. My name is Tim Bunger, Deputy Chief of Discipline and Probation. Before getting into the intervention update, as I know public comment has touched on similar issues historically, Even though I'm giving the update today, I have no involvement whatsoever in the intervention program. We do keep that program very much separate from enforcement. I'm simply filling in for Shannon being out and not anywhere involved as much at all with intervention, but just here as the spokesperson today. The highlight I wanted to start with was at the February 28 through 29 board meeting of last year. The board voted to allow staff to begin drafting regulatory language for revision and or additions to the California Code of Regulations, Article 4.1 related to the intervention program guidelines. As of December 31st, 2024, the contract with Maximus, who had previously been our vendor for the intervention program, ended. And so starting on January 1st of 2025, we've now been working with Premier Health Group, who is working with not only us, but DCA and 8 other healing arts boards to provide the intervention program and working to make sure that transition is smooth and with as minimal impact to the participants. The board also continues to recruit IEC members with knowledge or experience in substance use disorder treatment, recovery, and mental health. The board put a request forward to the EIIC committee that was approved to move forward to this board meeting regarding the reestablishment of up to 5 additional IEC or intervention evaluation committees. And then as of February 12th, 2025, the board has over 30 IEC member applications that may be eligible for consideration by the board. Any questions I can answer?
Thank you very much, Tim. Lori, is there anything you'd like to add?
So just on here, I know that we have the upcoming discussion on, sorry, let me grab my notes here really quick. I apologize. So 5.4. Yep. So sorry. 5.6 is when we're going to reestablish some of the intervention committees. One of the things that has been brought to my attention as I've been working with the intervention and kind of doing the review is the need for consistency within the committees. And so with that, talking to some of the board staff, there is an idea floating around that they may consider opening up a committee with a specialty focus of relapse or opening up a committee with a specialty focus of completions or entering the program. And that way there is some consistency. What we do know that when you have multiple intervention evaluation committees within the intervention program, those committees have separate professionals. And so they have their own doctors, their own nurses, their own public members. And although we do give training that is consistent across the board, the interpretation of that training may be a little bit different. And bringing in their experience that they have, which is a requirement for them to be on the committee, they pair up differently in different committees. And those committees, what I've heard in just doing the meetings and the reach outs is some committees may make decisions differently than the next committee. And so really working on what to do to bring them better in alignment. And so that is something that will be explored as we look to open up those committees going forward. Additionally, with Premier Health, we are now giving twice a week trainings. And I say we, not as me, but as the greater we. And so we do have Jaspreet and Shannon and Yvonne involved in those trainings, as well as multiple people within the Premier Health Group. And they are meeting with them just to ensure that this transition goes very smooth. So there is a lot going on within the intervention program. The other thing that was kind of reported out as part of the enforcement update was the National Council of State Boards of Nurse pilot study. With that study, we expect them to complete the data collection of that within the next year. It's projected, and then they will follow those participants not in an actual following case, but to see if there is relapse, they reenter a program. And if for 2 or 3 years post completion of the program, and then that will be reported out to us. And so as Tim had shared in that enforcement update with the intervention program, that because we meet those minimum qualifications that NCSBN has, where we do 3 years minimum without relapse, that they do daily check-ins, that they do include holidays and weekends, that they do test at least twice a month, and it is random in time and test, and that they attend 2 meetings a month that are structured support, and at least 1 meeting a week that is mutual support, that because we meet those minimum requirements that are evidence-based, that we were allowed to enter that program. And so those were the requirements that were evidence-based that showed successful completion. What NCSBN is looking is now you have that successful completion. Does it actually help to ensure that there's no further relapse? And so that is where we're really kind of looking at how can we streamline that intervention program and still become in compliance with that pilot, because we do want to be part of that evidence-based and see what happens with that.
Thanks very much. Lori, you said we're doing training every week. So it's our new vendor and our intervention staff and the IEC.
No, IEC is not included in the training yet. And so we will be doing training for IECs. We had internally made a plan to do a annual kind of update and just kind of keeping in contact. That would have typically occurred in December. It did not occur in December this year because of the transition to Premier. So we wanted to transition to Premier, and then we will do updated training.
Thank you very much. Are there any questions or comments from board members at this time?
Vicki.
Who are you pointing to?
Vicki.
Oh, Vicki, go ahead, Vicki. Thank you.
Thank you. When you say that staff is doing training, what is the training and who specifically is the training for?
So we have Premier Health as the new vendor, and so Premier Health has a background in substance use disorder and mental health. What they don't have a background in is regulatory and statutory law. And so they came on to the to DCA and the 8 Healing Art Boards. And what they're now trying to do is learn and follow the uniform standards, and then learn and follow any of the board specific or bureau specific statutes or regulations specific to intervention. And so with that, because there are subtle differences between each one of the board and bureaus, and following the contract with specific board callouts, it's trying to get them all in alignment with what the expectation is for each one of our boards and bureaus.
I'm assuming that, can I follow up?
Yes.
Okay, because I got a string of things. But as a follow-up to that, I'm assuming they're aware of what we've been dealing with for the last year.
They are. When we first secured contract, I did have a meeting with the CEO and let them know of some of the issues that had occurred in intervention, and provide them links to our website that has the webcasting and the meeting minutes, and offered that it would be a benefit for them to watch the meetings. And if they could not watch those specific meetings, specifically the June meeting and the August meeting, that if they went and reviewed the meeting minutes, that would be helpful for them to get a baseline.
Okay. And I mean, I don't remember, I'm not exactly sure if it's appropriate, but I'm sure all of us received a letter from Stephanie Trum.
That letter was received. My awareness is that it did go to all the board members, myself, Department of Consumer Affairs, and legal.
Okay. So I don't necessarily want to get into specifics in here, but it did bring up some issues that I want some clarity about, because is it in regulation? Is it in the process that staff attends the IEC meetings and gives direction to the IEC group. Is that something that has always happened? Is that new? Will that continue? Because my understanding is that while our staff might be experts in regulations, I don't know that any of them have any background in substance abuse, recovery, mental health, chemical dependency, law. I mean, obviously you pick up a lot of that in doing the job, but
You do. So there are various parts in both statute and regulation that do require oversight of the IECs as well as the nursing support group facilitators. That oversight is shared between typically the program manager, that is someone that is designated by the EO. And we also have a requirement in there for the vendor to visit the nursing support group facilitators as well and do kind of spot checks through that. So there are requirements for that oversight to occur. And there is a requirement for the program manager to participate in the IECs. The one thing with the IECs is that the board staff is there to not provide guidance necessarily, but they are to kind of interpret any of the regulations that they may have questions about or any of the uniform standards. But they would not be the one to give recommendation on how to manage the participant. It would only be recommendation on, not recommendation, but only guidance on what that uniform standard means or what that regulation means.
is there any training for your project program manager on issues related to chemical dependency? So they have some baseline knowledge?
So there is a requirement that that program manager have some baseline knowledge on that. And I'm trying to find that in our law really quick. It 2770.1 Business Professions Code C, it says program manager means the staff manager of the intervention program as designated by the executive officer of the board. The program manager shall have background experience in dealing with substance abuse issues.
Is there any definition for what that means?
No, that is the only statement that is in law right now.
Okay, because that could mean that they attended one AA meeting or one Al-Anon meeting, but not that they actually know. It's complicated. I mean, that was the population I worked with for a decade. And it's very complicated, and particularly as we're doing evaluating whether people are safe to return to practice, it seems like there'd be a lot of tension, which is necessary, but it seems like there should be some idea of what it means that they have some background.
So, and I think I understand where you're kind of going to, but what I want to reinforce is what the IEC committee is. The IEC committee says that each committee shall have the following composition, and that is 3 registered nursing holding active California nurse license who have demonstrated expertise. So not just that they have a background, but
I'm not,
demonstrated
Lori.
expertise in the field of chemical dependency and psychiatric nursing. So even if my program manager doesn't have an expertise and only has a background, it doesn't mean that our IEC committee that they're attending doesn't have that expertise experience. And so even the one physician in there has to specialize in the diagnoses and treatment of addictive diseases and mental illness. And the one public member has to have knowledge in the field of chemical dependency and mental illness. So the IEC is the expert panel that is supposed to be responsible for evaluating the intervention participants' program compliance. That the program manager just has to have a background and, again, help with and aid in interpreting our rules and regulations and the requirements of our program.
So who trumps?
IEC members would vote together and they would trump always.
Okay. If you've got people coming in and saying things that are, this is law, that's going to be intimidating to, they're basically volunteers. I know they're getting some remuneration, but they're basically volunteers. And people in the helping professions tend to listen when they say, here, this is law. So how do you deal with that conflict?
I can't say that it's definitely intimidating. I can't see how you could think that, but I don't know that that happens across the board. What I do hear in when I'm meeting with people and kind of going through this process is that these professionals that have the background in chemical dependency and psychiatric nursing and mental illness, et cetera, they do defer to board staff on the interpretation of the rules and regulations. They know that that is not their area of expertise. And so when board staff interpret those rules and regulations, what my understanding is they try to take their expertise in their fields of chemical dependency, psychiatric nursing, mental health, et cetera, and see what that expertise can do to lend to the law. And so I don't know if it's an intimidation, but I think that they're trying to do the best that they can with meeting the requirements of the law as well as utilizing their professional experience.
I realize I'm monopolizing and I don't really want to do that.
No, they're great questions. I appreciate it, Vicki.
Okay, because I can continue on, but I mean, it's not my meeting.
I mean, you are an active board member, so it is. With this, what has been discovered is that we do have the program manager in attendance. We do have other board staff in attendance. And as I've said in previous meetings, the plan is to decrease the attendance of board staff. And the goal is that my assistant executive officer will stop attending IEC meetings, as well as the chief of enforcement will stop attending IEC meetings. But that was going to occur after Premier is stabilized. So with that discussion that I shared out, I believe in the August or November board meeting, talking about transitioning them out and leaving it open to the program manager to be the one that's in attendance. It was to phase them out, but then we got a new vendor in. And with this new vendor, there is some support that needs to happen. And right now, both the assistant executive officer and the chief of enforcement are lending that support. The goal is to have that support not be required as Premier comes in with a better understanding of the rules and regulations, their role as the vendor, and really the role is the CCM. So we have a CM and a CCM, and they work with the intervention participant on a routine basis. They are the ones that they do the check-ins with. They require the essays. They manage the implementation of their recovery agreement. And as they become more comfortable in that, they will take a more active role in the IEC committees. Again, they're brand new to this, only within the last 2 months. And so what we will see as this progresses is our staff will take a lesser role and be less present in those meetings. We will still have our program manager continue in that role. And the CCMs will give their interpretation of the participants' progress in the program, because they are the ones that are dealing with them on an almost daily basis. The IEC will still be the ones that make the recommendation. That committee is the one that evaluates all of that information coming in to see what that participant is doing and how well they are doing in the program, and they will make the recommendations based on that. But that is kind of what happens in a closed session process with each one of our IECs.
I'm going to try to ask one more question and then.
Yes.
But so when a participant is trying to do their interview with the IEC to look at potentially being graduated, is there any consistent format for how that should go, what the standard questions are, the minimum and maximum amount of time per client? Because we've heard from public testimony that that's kind of been different with the change recently. And in the letter, there was some discussion about how it was often inconsistent and inadequate and challenging for the participants to make a case.
So that to me, I'm going to break it down to a couple different questions. So prior to the changes, my understanding when meeting with the prior vendor and prior IEC members was that there was not a lot of structure to those meetings, that the IECs would come in, that they would meet with the CM or the CCM, the clinical case managers, and that the participants, and that they would just kind of ask questions and kind of talk about what was going on. And there wasn't a lot of structure to that. And then that they would have recommendations, they would ask the participants a lot of input too into those recommendations. And then a recommendation would be made. And that recommendation wasn't anything that was structured either. It was all just kind of fluid because it was a process that they had been doing for about 40 years. And as we had identified in the August meeting when I was reporting out, is there had been some drift, and that potentially all regulations and all statutory requirements were not necessarily being met, and that items that were in the contract with the last vendor may have been altered and changed on a vote, but not necessarily in alignment with what the regulatory requirements were for each and individual Healing Art board. So on that review, it was also discovered that Bagley-Keene was not necessarily followed to the dot at every meeting as well. And so with that, the board staff came in and aligned it into a appropriate business process that followed the rules and regulations at that point. That was a very difficult transition for people that had ran those IEC committees the old way that had kind of drifted. And so when those changes were implemented, it did seem like it went from a very kind of relaxed meeting to a much more structured, and some did interpret that as maybe a colder feeling meeting. That was never the intent, it was not the intent to drive any kind of barrier between the members and the committee or the participants in the committee. It wasn't an intent to push people out and not take those into consideration. The intent was to bring it into compliance with the rules and regulations as interpreted. When that happened, we did have a lot of complaint because the participants were saying we didn't know what to do. We weren't sure how to manage that. I was scared when I went in. So they did ask for some CCM help. That is something that is now occurring with Premier. The clinical case managers do meet with their participants. They do prep them on what to expect with a meeting, and they do go into those meetings with their clinical case managers, typically in attendance. What has not occurred, which is what is being asked to occur, is that the CCM give a report out in the meeting of what they believe that participant is doing in regards to their program. It's not that it hasn't occurred on purpose or sorry, by us leaving them out. It's again, we have to remember these CCMs have only been in this position for 1 or 2 months. They are still hiring in more CCMs to cover and be assigned to the participants. So they're new to their roles. So right now those CCMs are present, but they're in more of an observation type of role.
Sure.
And they will be having a more active role in the future as they become more comfortable with that so that they can give their professional opinion. Because again, our CCMs are either LCSWs or RNs. However, they're assigned with the working experience in mental health and substance use disorder. So they will have the opportunity to give feedback to the IEC committee on what they believe that their intervention participant is working well within the program. What we want to make sure those CCMs do is not influence the decision of the IEC committee, because we did hear in the past that the CCMs potentially could have been influencing decisions of the IEC. So what we don't want the CCMs to do is disagree or try to redirect any of the IEC members. We want to keep that completely separate because that is what we had heard previously may not have occurred 100% of the time. So it is a structured environment. The participant does come in and have an ability to interact with the committee. The CCM has not interacted much with the committee, but that will be changing. And yes, our board staff are present. It is the plan to have only one board staff in there. I have met with the Department of Consumer Affairs to kind of make sure that we're doing similar things as the other boards and bureaus. And one of the requests that I put out is we do have legal representation in each one of our advisory committees, each one of our board committees, and each one of our boards. This is considered a board committee per Bagley-Keene. It doesn't get pulled onto advisory committees, why they have to meet and have a in-person location and be public. And we have asked that if DCA would be willing to allow us to have legal in those meetings as well with that program manager so that there is 2 in that meeting going forward. And I have not received a affirmative yet from DCA, but that is something that they're looking into.
Okay, thank you, Lori. That's very comprehensive. And thank you to my colleagues for indulging me.
Good questions, Vicki. Thank you for asking. Are there any other public comments or not public, board questions or comments on this item? Okay, it is information only, but we will take it out to public comment. Would the board moderator please open us up?
Board moderator, if you're speaking, thank you.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I want to give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." DJ H would like to make a comment. 1 second, please.
It is now. Firstly, I just wanted to say I had my last IEC in January, and it was a completely different experience than previous IECs, and it was a positive experience. Previous IECs, I had waited an hour up to almost 3 hours for my IEC to start. And in this instance, actually, I was notified by Premier that they were running a little bit behind. And so they gave me about 30 minutes past when it was originally scheduled and told me this is when it's going to start. I logged in, and within 5 minutes of the time that they told me it was going to start, it started. and I was given ample time to make my requests, to share information, to ask questions. I was continuously asked by the IEC members, do you have any other requests? Do you have any other questions? Is there anything else you would like to say? They asked me some questions, and then the meeting was ended. So it was such a positive experience. I felt heard. I felt like the committee was engaging with me. So I just wanted you to know that and how much I appreciated that. My question is Premier Health, are the CCMs getting information about the oral tests? Because my CCM had no idea what that even was. Or that we were granted permission to do that on certain situations. So I just wanted to know if that education is getting across to them. Thank you.
It is now. That was something that was not highlighted in the first month. And as discussions ensued, we realized that they were not aware of a saliva testing or the oral testing, as you referred it to. And so that is something they are now aware of. Vault does still offer that, and that is something that will be put into rotation.
Thank you.
I sure appreciate that feedback. Thank you.
Thank you for your comment. Lori NP would like to make a comment. 1 second, please.
For dealing with my comments as well. I appreciate all this information about the intervention program. I do feel like in terms of evidence-based practice, pertaining to the NCSBN study, the evidence that the rest of the country seems to be using about their substance using population of healthcare providers indicates that California is overdoing it in their enforcement. And I think part of the reason that we're not involved in like the compact states and all of this to do with NCSBN is that they've even said we're overdoing it. We were overdoing it. You guys have admitted, or we've admitted that. And you know, I think it's true. There's been a lot of inconsistency, and potentially inadequate following of the regulations. And thank you for explaining that all. But there's a lot in terms of evidence-based practice. Nothing about this meeting makes me feel like the practice of nursing, as far as enforcement, is evidence-based practice, particularly in California. If anything, I feel like we're posing to get into this study with NCSBN because we're not following the evidence as far as recovery and how to and I have a hard time, I'm sorry, speaking because I feel strongly about this. The other thing I just wanted to say before my time is up is I would encourage the board, please, to look at the numbers in terms of the RNs or NPs or advanced practice nurses who have surrendered their license after probation, or their numbers have, or the people who have, because we've been encouraged to go on to probation and then surrender our license. I was encouraged to do this. And I think that when we do this, our voice no longer matters because we are so broken. We wouldn't come to board meetings and embarrass ourselves like I do. And so you don't hear from us. We go away. And I'm not going to go away because this is wrong. And I just want to know when we're going to find out the rest of this. I think potentially people are being miscategorized. Something is going on, and I would like, thank you for looking into it. I appreciate it.
Thank you. And we do encourage all participants, whether it's intervention or probation, to please speak up. Again, if you guys are not letting us know that there are issues to look into, we won't know to look into them. So I do appreciate you speaking up and having the courage to do so. And we will always continue to look at this for any kind of process improvements so that we can better serve.
Thank you for your comment. Committee Chair, Board Member Nguyen, there are no other public requests for comments on the WebEx. Do we have any public requests for comments there in person in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Thank you very much. Any further comments from board members? Hearing none, this again was an information only item, so we're going to go ahead and move on to item number 5.5. This is discussion and possible action regarding the requirements for a participant of the intervention program to be reinstated to a full unrestricted license, including but not limited to the requirement that the participant demonstrate that he or she is able to practice safely. And I think Lori will be presenting on this, and there'll be opportunities for discussion.
Yes, I will. Thank you, guys. So part of the August board meeting was for the EO to do a re-review, sorry, not a re-review, but a review of the recommendations that came out of IEC in order to make sure that they met certain specific guidelines. And in doing so, I started to notice some different items that may need further clarification. And one of the issues that came up is, what does it mean to demonstrate that he or she is able to practice safely? And so opening that up for further discussion to get some involvement of our board and feedback from our board, and really kind of share with you what I am learning as I go through this, what I am hearing, and what DCA is expecting as well. Understanding that the uniform standards are BCA based. That's the law that lives within the Department of Consumer Affairs. That is part of the direction that comes down to their boards and bureaus that utilize this process. So uniform standards, when I first was in kind of coming into this and trying to learn about it, I reached out to our director, our Department of Consumer Affairs director and deputy director to say, you know, what was the intention of uniform standards? How did it come about, and how does that work? And the one thing that was made very clear to me in those meetings was that these uniform standards are focused on recovery, and that demonstrating, if you go through on uniform standards number 12, it says the licensee must meet the following criteria to request petition for a full and unrestricted license. Number 1 says demonstrate sustained compliance with the terms of the discipline order if applicable. Understanding that there are some probationary individuals that fall under uniform standards and use those same guidelines. Number 2 says demonstrate successful completion of a recovery program if required. And that's where our intervention participants fall in. They do not fall under number 1, but they do fall in under number 2. So they have to show that they have successfully completed the recovery program. Number 3 says demonstrate a consistent and sustained participation in activities that promote and support their recovery, including but not limited to ongoing support meetings, therapy, counseling, relapse prevention plan, and community activities. Again, all of that is recovery based. And then I'm going to skip number 4 for a second and go to 5, which it says continuous sobriety for 3 to 5 years. Again, completely recovery based. So when I asked about number 4, demonstrate that he or she is able to practice safely, what I was consistently told amongst the other healing art boards, as well as with DCA leadership, is when the IEC evaluates that, do they believe that they will be able to practice safely without a relapse? Again, very much recovery focused, right? What they said is that that doesn't necessarily require that they work as an RN, or an RN with patient care, or an RN with narcotics access, usage, passing, anything. What it says, according to the feedback that I've received from having those discussions, was that practicing safely meant that they will not relapse and that they will be able to then go on and practice safely. So that is where we're running into issues with IEC interpretation, what may or may not be needed for our participants. And we do have some participants that are caught in a loop where they have not worked as an RN and they have completed all of the other areas, 1, 2, 3, and 5. Those are easy to be demonstrated. Those are something that is very just kind of checklist based. Yes, you've done your recovery program. Yes, you have sustained and consistent participation. Yes, you have continuous sobriety. Those are really easy to kind of mark off. What our IEC committees are having a difficult time is how are they ensuring that they're able to demonstrate that he or she is able to practice safely without them practicing. And so that's where I really want to open this up to the board to get some feedback. I've given you the feedback that I have received from all of the other Healing Art boards, from our director and deputy director of DCA on what the intent is. But I do have participants that have met all the requirements but have not practiced as an RN during their entire program. They do state that they are not able to get a job or find a job, that they're running into barriers. Some have said that I don't want to work anymore, but I don't want to give up my license. I want a license and I want to complete this program. And so if there's any additional feedback from you guys, I would love to take that into consideration. I know based on whatever is discussed here, I have been asked to have a training on for our IEC members to make sure all of this stuff is recovery focused and that their role, which is outlined in our business professions code, is to evaluate the participants' engagement in the program and not outside of that, to make sure that that is still following. And then we will be looking at the nursing support group facilitator process as well. One of the things with that is when we're looking at this, demonstrate that he or she is able to practice safely. They're going to those support group meetings, they're having conversations, they're being kind of directed within those in more of a directed recovery manner. So we want to give training to all of them. And then we will also be looking it up, because when I did look at the NCSBN study, the NCSBN study talked about a program called Caduceus, and that is a nursing support group like a program. And so we have AA, NA, all of those kind of programs here. Some of them are 12-step based, religious based, some are not. We have routinely given nursing support group, and that has some very specific guidance. It is not outlined in our law. That is something that, as we look at the regulations, that might be something that we address. But the NCSBN study utilizes Caduceus, which is a healthcare-based support group. And so if we did open up that, we would still be in alignment with what NCSBN's study was and what that evidence base is. So that might be something that we explore as well in that training. So we will have training, but I want to get kind of what this practice safely is to our board members. What does that mean to you? Because these IECs are making recommendations for our board.
Thanks very much, Lori. And I'd like to open it up for a conversation. As Lori said, she would like to hear some feedback. So I, of course, am interested in hearing the experience of other healing arts boards, and I think we've gotten that. So thank you for that. I think maybe we've been an outlier. I'd be interested in hearing what other states are doing going forward, maybe not this afternoon. I do know we've kind of been in a hellish place for about maybe a year or at least 9 months. And I've spent a lot of time thinking about this since we started these public hearings and really hearing back from nurses. And I guess I've kind of narrowed down to here. When we have nurses that come into our probation program, oftentimes there has been a problem with their safety to practice because they've made mistakes in the workplace. But on the intervention program, that's something that's voluntary, and they really have gone in because of either an addiction issue or a mental health issue. So I think intervention, really, we should be focusing on wellness or recovery, sobriety, and probation, we should be focusing on competency. So again, those are just my initial thoughts on this. I do have so much empathy for the nurses that seem to be caught in this loop, and we hear from them every board meeting, and it just is heartbreaking So that's kind of one of the places that I'm starting from. And I would welcome comments from other board members.
So a couple clarifications really quick. It is an alternative to discipline program. So our nurses that voluntarily join intervention may have some discipline that they are doing this in an alternative to receiving that.
Okay, thank you for that clarification.
That discipline, however, may be addiction related, right? Where it is they had a DUI, where it is they were diverting, that kind of stuff. So I think you do have kind of the right thought process with that, but I want to make sure that it's not just kind of cut and dry. Our probationers, what we do see more frequently in probation is that there was a knowledge deficit, that there was maybe they missed something in their RN training, or maybe that was not something that they had experienced before, where there was a negligence or an incompetence that occurred that was practice related. We've seen cases where they hung blood on the wrong patient, where they missed a failure to thrive diagnosis and an infant or whatever passed away. So that shows to me that is a practice based and that's a knowledge based issue. And that's something that we can address with education, with a RN refresher course, with having that maximum supervision when they're out there taking care of patients to make sure that there's not another error like that occurs. Intervention is focused on substance use and mental health. And so you look at how are you managing your substance use? How are you managing your mental health? And hopefully by addressing that, your practice is consistent. And so it's not necessarily fixing a knowledge deficit on your practice side that you were prior to being affected by the mental health issue or the substance use disorder, practicing fine and safely. So addressing this should be able to bring them back to that competent level.
Thank you, Lori. Any other questions or comments from board members? David, go ahead, please.
At the risk of putting my foot in my mouth, because I am a public member, let's remember that, not an expert in the hospital fields. If we're only talking about these specific nurses who were not working, and the catch-22 is if you're not working, you can't show you're safe to practice. For the one subset who don't plan on working anymore, but for whatever reason want to keep their license, could we, or is there a system or an option to freeze a license or put it in an on hold space until they can someday find a job, and at that point meet this one last 6 month or whatever it is criteria? And I suppose my follow-up to that is there a deadline or is there a time certain when it must be done by to get their license back?
So when they're in our program, they have their license. They typically at the very beginning, they have to be off work for 30 days at the very beginning when they enter the program. They have to have negative tests. What has happened historically during that time is the participant, when they join, inactivate their license for 30 days. Okay. And then after the 30 days, they reactivate their license. And then they are released kind of on a basis to get them to a full practicing license. So the first one is, yeah, you can go back to work as an RN, but you can't do patient care. And then the team evaluates their sobriety and their compliance and their mental health. And they see, we feel comfortable now that we're watching all of this happening, that you can do patient care. So that kind of heightens that level just a bit. And so then they manage them during that time to say, yes, you can do patient care. They can decide to return them to patient care with access or without access. Those are the Intervention Evaluations Committee's review of the participants' participation and the review of whether or not they believe that they are managing their addiction in a way that doesn't make a risk to the public. And so they release them to that. The expectation is that when the IEC members release them to being able to practice and have patient care and have access, that they believe that they are managing their sobriety well and their mental health well, and that that is being taken care of. The time in the program is not based on employment. It's based on 3 to 5 years of continuous sobriety. Once that is met, they look at the rest of the timeframes. Is have they just demonstrated sustained compliance? Have they completed their recovery program? Are they participating in all of the areas that support their ongoing recovery? And does that then demonstrate that the IEC believes that they can practice safely and not relapse? Because that relapse is where that public risk comes back in, right? So there is some thought within some IEC members that they need the stress of being an RN. And they need to actually work as an RN under that stress and see if that's something that they can do while they're in the program. That is a thought, but if that thought is there and they're not able to find a job.
So that's my second of 3 questions.
Okay.
Therefore, in the past year, one of our discussions was these nurses are sometimes working as case managers.
Yes.
That's a nurse's job. They don't have to deal with narcotics.
Correct.
Okay. I can't deal with the IEC issue right now. I don't know anything about it. But here's my thought on that. We have 103 NP. We have 104 NP. Okay. What would it take, just an idea, to have a modified nurse's license that says you are a DUI NP, something nicer than that. And so you can be a case manager and all these other jobs, but because of what your license is modified with this specific number, you're never going to be hired over here with patients and narcotics until you pass that barrier.
So because our intervention program is 100% confidential, we do not have any of that ability.
Okay.
So when they complete this program, they have an RN license that is completely unrestricted.
Okay.
So there is an opportunity for a nurse to say, I don't want to be a nurse, but I want my license. I will never work in the ER ever again. And they tell that to everybody. They do all that. They finish the program. And for the first 2 years, they don't. But at year 3, they decide that they want to go back and be an ER nurse. And they go and they be an ER nurse. It is less monitored in there. They do have overwrite abilities where they can access to the Omnicell and pull out medications. And they could get access back to those issues that got them here to begin with. However, the caveat to that is if they have been working their program like they should, and we have watched them do for 3 to 5 years, the idea is that they will face all of these kind of stressors in their future, and they will go back to their tools and work their tools. And so that they may be able to go into those roles in the future if that's what they choose to. If they don't and they relapse, our program is here again. If they have successfully completed our program, they can always come back into our program at any point.
Okay, so I'm done. This is my last one. So here's my last idea. You can't get a job because of whatever reason. You're in the program. We have to meet this requirement of safe to practice. What do you think about the idea of, if I can't get a job in a hospital doing that because a hospital won't hire me, would I be able to, in a reciprocal way, meet that requirement through one of the schools who their nurses are doing clinical? Or if they're not, they're doing it in simulation. They're practicing nursing, right? Well, if I need to show you I can do this safely, and I don't know in my ignorance if there's actual narcotics in a simulation room, but would they be allowed? What do you think about the idea of, you're not going to get hired? Okay, we'll put you in this college has agreed to accept one in their cohort who needs to meet this requirement. Let's watch them practice. Yeah, they're safe. So it's a simulation, whether it's in the hospital or in simulation.
So that comes back to the same idea, is they are working in a school is still required an RN license to do so. So they would still have to work as an RN. We do have intervention participants working in our schools while in the program. And so the other thing that comes into play with that is they have to meet the qualifications of that faculty member, which means they have to be recent in practice. That recent in practice is 5 years. If you've been in this program for 5 years and you have not practiced, you no longer meet that recent to practice. So they would not even qualify to go into that specific role, whether that is simulation or not, because the faculty that we approve are simulation clinical theory altogether. They're not divided out. And so that's the limitations with our license, is that we don't have a probationary license, an intervention license to give them, because it is confidential. So the idea with this is when they complete the program, they have an unrestricted license. They can do whatever they want. The purpose of the program is to ensure that they are sober and in compliance with everything and have the tools to practice now without relapse, because that addiction and the relapse was the public risk, not their ability to practice as an RN. The knowledge deficit is not what brought them into the program.
Right.
What brought them into the program was their addiction or their mental health.
Thank
Now,
you.
yes, and one of the questions that Tricia had mentioned is, what do other states do? There is not a consistency from state to state. There are some programs that are offered within other states that require the participant to be off work completely for the entirety of the program, and there is no work requirement. It is like an intensive rehab. And so they do a 1-year program, and in that entire year, they are not working. They finish that program. They have demonstrated that they are sober and have maintained compliance. They get their license back. They are then able to work. But we have them work during our program. That has been changed since the board motion in August. We allow them to work instead of require them to work. However, we're still having some that are caught in this loop where the IEC members want to see them practice. There's something in their sobriety that is giving the IEC some hesitancy on completing them. I did bring up some of those suggestions when talking to other EOs, and they said, again, that doesn't look like that's work focused. It's not work and show me you can do this. It's a sobriety mental health focus. What do you do at that point to support them in their sobriety and their mental health? That's not a work requirement. That what that's telling them when they looked at it from an outside kind of point of view was, that means they need more work on their sobriety. They need more work on their mental health. If they're having any concerns that they're going back to work could trigger them to a relapse.
So basically, it seems like the bottom line is really how well they're managing their sobriety.
Yes.
Right? It's not that they need to be put in a narcotic environment. It's not that they need to be put in a bedside, especially since if they haven't worked those areas before, that alone adds a monumental amount of stress. So, and that alone could, I mean, they could fail in some way or another, right? You don't want to put them in that situation.
It could be more practice-related failure versus mental health or sobriety failure
True.
at that point, because you haven't been practicing in that way. You would be more open to errors. But this is beyond that. This is, what if they can't work as an RN at all? That's the question right now that our IECs are struggling with, is we have people that are have health issues where they may not be able to, based on health issues, be able to work. Some of them that have spinal fusion, some of them that have severe pulmonary hypertension, some of them that have no ability for them to even continue to work. They're pretty much in a kind of disabled type of status. Sure. And in order to finish the program, they still want them to work. And again, that's not all of them, right? So some of them, it's just they've been looking for a job. They've applied to 100, 200 jobs.
It's not easy.
And they're not getting it because they do have to, when they're going in for these jobs, they do have to release that they are in this program. So it is not confidential to their
Yeah.
work. They do have to have a worksite monitor. So it is not confidential to their work and their worksite monitor. And so they may be not able to find a job because they haven't been working consistently because they're being in this program or because they suffered from mental health and substance use issues previously. And then now that they're at a place where they're healthy enough and supported enough to get a job, they are not able to find a job. And so they have demonstrated that I've applied at 100 different positions. I've applied at 200 different positions. I cannot get a job. They've met every other requirement, but the IEC does not feel comfortable because without even working as an RN, how can they say that they've demonstrated he or she is able to practice safely?
Exactly.
But that is where the Department of Consumer Affairs and other EOs have deemed that as that working is not a requirement to demonstrate that they're able to practice safely. That the way they demonstrate that they practice safely is by not having that addiction be an issue to interfere with their ability to work, that they believe that they will not relapse.
And that comes down to managing their sobriety, right?
It does. It doesn't
Yeah.
come down to managing their work or working as an RN, is what the other EOs and what DCA has interpreted this to me to say.
Thank you.
And so, Board Member Patel here, how do we further differentiate then to advise the IECs to ensure that, they're really taking into account practice-related issues versus substance abuse, mental health-related issues, and ensuring that, we're not muddying the waters between the two, essentially. So does that require a different policy that we have to devise as a board, or
Well,
how can we ensure that
the
doesn't happen?
things that EO Melby said is if we give her some direction, then she can give direction to the IEC. So are we saying safe to practice means you have to go practice safely? Or or is it like you're safe to practice because your sobriety is not at risk? I mean, that's my interpretation, Lori. Please correct me if I'm wrong.
I mean, honestly, direction from the board is helpful. If it is going to be a regular and consistent application, we will have to pursue regulations, right? So one of the Healing Art boards, they do believe that working is necessary. And so a Healing Art board did say that they had to work while in their program. And so they pursued regulations for that. We don't have regulations for that. And that is why we cannot hold them to that. But if an IEC says, I think you need to work as an RN before I can sign off that you've demonstrated that we will be able to practice safely, that's the ongoing loop that we're in with a couple of our participants right now. And that is when I sought outside help at that point. I say, hey, I have people in a loop that I don't have sufficient evidence that they need to extend in this program, but our IEC keeps saying they need to work. They keep saying they can't work. They've met all the other requirements, but they're in a holding pattern until they can find a job. They may never find a job. And so I can't keep them in this program for 5 years, 6 years, 7 years. They either need to get a job so they meet the requirements of the IEC, or else I have to re-educate the IEC to say getting a job doesn't demonstrate that you're able to practice safely. That the intention of number 4 is, do you believe that they are sober and they have the tools enough to say they won't relapse because that addiction is what affected their ability to practice safely? And that's where we really need to come down to a re-education to the IECs if our board agrees. If our board is like the other Healing Art board that says, no, I really think they do need to work, well, then we need to pursue regulation and put in a work requirement. Our probation does have a work requirement. It has you work 20 hours a week for 6 months at minimum, or you don't pass probation. So that is a requirement that is put in there. So we don't have that in intervention. We would have to do regulations to do that.
So Lord, can I just say it's
Yes.
24 hours per week?
24, sorry.
And I do want to just, earlier, somebody had questioned, in probation, as of Monday, we have 336 CD cases, that's what we call
Yes.
chemical dependency, and 346 non-CD cases, so those would be the practice cases.
Yep.
So it's almost an even split in our probation. And as Lori had mentioned, they do have a requirement of working 6 months for at least 24 hours per week. And their worksite monitor, it's a much stringent. In the beginning, it's, they have to be, the worksite monitor has to be with them full-time. I believe that's called the moderate, and I mean, and then it steps down. But to where on our intervention, a lot of the recommendations from the IEC is that the worksite monitor needs to check in with the participant at least once a week.
Yep.
So there's not that one-on-one.
Yeah, thank you.
There could be, but that it's not required as it is for probation.
Thank you, Yvonne. So I think Ms. Patel has a question and then Mr. Lawler. No, sorry. Go ahead. Go ahead.
Somewhat piggybacking off of what Nilu said, and thank you for those numbers, because that goes to my point of there seems to be two different issues here in practicing safely, and one is practice and one is safely. If I'm a drug and alcohol or chemical dependent person, managing my sobriety will show you that I can be safe, because I don't need to work in a hospital to get drugs and alcohol. I could do that on the street corner.
Exactly.
No, that doesn't help my practice, because if I'm out or if I need to do procedures that you need to see me do well, competently, proficiently, that's the issue. That's why I said, can I at least show you I can do that in simulation until someone hires me? Because they're not going to hire me with this on my.
And I just want to make it, the recommendations on the IAC are typically not, you must work in a hospital. I mean, they've had people work in volunteer positions at clinics like one Saturday a month. And there has never been 6 months for X number of hours. The IAC, it definitely is since I've been attending, it's a case by case. They look at that participant, where are they at in their recovery at that moment, and what brought them into recovery. There are individuals in the intervention program that their substance use disorder never impacted them at work. So their recommendations may be different than somebody who had issues with their substance use disorder and or mental health at work. So it is very much a case by case basis with intervention. I know probation has very specific probation terms that they have to go through. But with intervention, it's very much a case by case basis.
Thank you very much. Board members, Cormack or Granowitz, yeah, please go ahead, Ms. Cormack.
Thank you. I think this is the beginning of a conversation, I'm guessing, because there's a lot here that we don't know. So I'm just going to state that collectively, but we're getting a better handle. And I think Board Member Lawler really hit it on the head when he said subset. As we've been learning more about this program, there are many people who want to get back to work as a nurse, and the program was, so we heard about that. But now it seems there's this other subset which has, so far I'm hearing 3 different groups. 1, I've applied to a lot of work and I can't get hired. 2, I'm disabled and I can't work as a nurse. And so that's not going to change. Some of those are not temporary. Or 3, I don't want to work, but I want to be done. And those seem like sort of different areas, but I guess one thing that came to my mind, different version of what Mr. Lawler was saying, is almost like an honorable discharge. I don't, again, it's confidential, so we can't say anything, but it seems like there's a category of, you have done the work that you need to do on your addiction, and you've been sober, and we're going to complete you because otherwise you're stuck here. But I think those are the 3 subsets, and it may be that there's different answers for each of those. So I really appreciate EO Melby's description as I sit here and look at number 4, that, this is not, this is about a recovery approach for number 4. And I think it's possible that we could have some policies here that will be applied to this subset of people. And I think that can probably be done in the context where most want to go back to work, and possibly the example that Ms. Leonard Taps just used of, there are some people who it might be appropriate for the IEC to say, you actually do need to work. So I'm feeling like this is the beginning of a discussion, but it does feel like there's multiple populations here that we've been using the same rubric for. And just because it's, we've helped the majority doesn't mean we have to doesn't mean we can stop keeping going. And for me, this comes back to, a comment I made, I think it was last year, about the balance of preventing a relapse for some, or not preventing a relapse, but ensuring that someone won't relapse in the environment in order to protect the public, versus preventing completion for others. And that's the we're right at the tip of that balance here. So what I'll be thinking about as we continue to discuss this is what works for this subset. It does seem to me like a subset, not the majority, again, based only entirely on the quantity of calls that we've heard over the past year and a half or so from people who want to get to work versus the people who are like, I'm done, I just want out. So I guess the only question I have is, I understand that there's some people who don't want to work, but they don't want to surrender their license. Perhaps, EO Melby, you could just talk about what surrender means, and is it viewed in a negative way? It obviously that word has the connotation, but help us understand why that's not a good outcome for someone who's like, listen, I just want to be done and I don't want to work. So that'd be helpful.
So there's a couple things that play in with that surrender their license, and Yvonne, you might need to help me out with this a little bit too. When they surrender, so outside of the intervention program, when you surrender your license, you have the ability to do it. You have to petition to surrender. It is a process to do that. If you don't want your license, you can inactivate your license.
Oh, I
But
see.
to actually surrender your license is a legal process that they have to go through, and they have to petition and go through that process. In intervention, you cannot successfully complete with your license surrendered. So that's the kind of hang up that we're having right now. You can't successfully complete with an inactive license. So you are completing intervention, right now with an IEC that may require you to work. You can only work with an active license.
I see. Okay. So that's definitely a bit of a catch-22.
Just to provide a little clarification, with intervention, you have a couple options you can successfully complete. The participant can withdraw, or the participant can be terminated by the IEC. If the participant withdraws or is terminated by the IEC, they are not then eligible to rejoin the intervention program at a later date.
Yeah.
But if they withdraw and they haven't worked, I mean, there's still, no one knows that there was any issue, right? They could.
No.
If they withdraw then yes, the board can then go back and continue the disciplinary action that may have been started when they entered into the intervention program. And depending on the facts of that individual, they could be deemed a public safety risk.
But if they self-entered, if they entered the program and no one else knew there was a problem, can they withdraw?
They can always withdraw.
Correct.
At any point, a participant can withdraw. However, at that point of withdrawal, and I'll read the statute that talks about it, sorry.
And as Lori's finding that, I just want to state that there are participants in the intervention program that do self-refer into the program. However, by the time they're in the program for, a set period of time, then the complaint is received and the investigation is done. So some self-refer quicker than a complaint could be filed and processed.
I see.
So 2770.7D says all registered nurses shall sign an agreement of understanding that the withdrawal or termination from the intervention program at the time when the program manager or intervention evaluation committee determines the licentiate, I can't even say that word, I'm sorry, presents a threat to the public's health and safety shall result in utilization of the Board of Intervention Program treatment records and disciplinary criminal proceedings. And so their time in the intervention program will be reviewed and could be used to determine that they were a public safety risk. Even if when they entered the intervention program, they did so voluntarily.
Okay. All right, well, that's helpful. Again, I think we've got to figure out an answer for this subset. And I don't know that we're going to be able to do that today because I think we're definitely going to need some public input. Thanks.
Vicki, did you have anything?
So thank you very much, Ms. Cormack. Very thought-provoking questions. I agree with you. We are not going to solve this today, but it is a good start on this conversation. I'm hoping that we will get some more interesting feedback when we go to public comment. So at this point, I'll ask the BRN moderator to open us up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Nurse 117 would like to make a comment. 1 second, please.
And moderator for your time. I really appreciate that this discussion is taking place because I am one of those nurses that are stuck in a loop in the intervention program. And it just sometimes feels like there's no light at the end of the tunnel. I've been sober for almost 2 years and I work a really strong recovery program and I've been completely compliant with the intervention program requirements. I do want to return to work as a nurse. However, I do not want to go back to my old position as an ICU nurse. I have no interest in going back to inpatient hospital care. I would much rather go forward with my nursing career as non-patient care or outpatient care. And I was interested in what Loretta Melby was discussing in terms of, I don't know about other participants, but I would be willing to sign a contract at the end of my participation in this program saying like I would not pursue a career in hospital because I don't want to go back to that anyway. I don't know like what that time frame would look. I don't know. I'm just saying like that if that's a possibility to give some of the board members like peace of mind that the public health and safety isn't at risk because I am managing my mental health and my addiction well. But I just don't know how else to prove to the IEC that, that's what I'm doing when I've, like Loretta Melby says, they can see my sobriety time, that I'm going to NA meetings, that I'm going to my NSG, my nurse support group meetings, like I'm meeting all the other requirements, but it's really hard when you can't prove to them that you can demonstrate to practice safely if they're interpreting that as you have to work as a nurse. So thank you very much.
Thank you for your comment. Stephanie Trum would like to make a comment. 1 second, please.
bring up. One is the BRN is the only health healing arts board that has a pure alternative to discipline program in California. The rest of the healing arts are often a combination of their probation and some kind of treatment going forth. I wanted to bring that up. I also want to bring up that recovery is about accountability and autonomy versus the mandate. I really think that it would be helpful for those who are disabled to still receive some support or some way of successfully completing the program as best as they can. Again, a lot of the committees, I wonder about a training for each consultant to really emphasize case by case, not based on philosophy or what they were brought in for necessarily, because they didn't have the tools at that time to deal with the trauma, et cetera, but to be able to really look at how they manage their sobriety and their mental health. Thank you.
Thank you for your comment. Committee Chair, Board Member Nguyen, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Well, thank you very much for those two public comments. It is helpful to hear, what people are going through, and I appreciate, as always. Board Member Patel has a question or comment.
And I'm going to need some guidance here, Reza, I think. I think we need to make a motion to really move this needle, because it's been now 4 board meetings that we've tried to address this situation, and we really haven't made any real progress as to how we're going to deal with all these people that are in limbo. And so I would like to make a motion that we now address each individual on a case-by-case basis and not require them to work. Perhaps we can consider, this is not a motion yet, perhaps we can have them consider the intended area in which they seek employment, and whether or not, they can successfully manage that. Lori, I need your help for this too, but essentially stating that we can't mandate those to return to work and look at it at a case-by-case basis. Does that make sense?
Yes. You want me to go first? Okay. So a couple of things there. The current status quo is that we have that language from the uniform standards that we all know is a little bit ambiguous about quote unquote able, demonstrate that they're able to practice safely. That's what we have to interpret. And the status quo is that that's being interpreted on a case-by-case basis. Pursuant to the board's motion towards the end of last year, that requirement of working in direct patient care and the requirement of working in a job where you furnish narcotics, those have been lifted by and large, except in cases where the IEC determines, based on the facts of that case, that there's some evidence requiring a need for that requirement. So I think, where that requirement might have previously been more wide, or those two requirements were more widespread, they're not as widespread anymore. And in the cases where I think Lori was speaking before about situations where the IECs in a particular situation just feel that based on that individual needs to work in order to demonstrate it, there is still the room for that. And I think that's appropriate. I think there ought to be, some discretion for that requirement where it seems to fit. So that's the status quo. By and large, those requirements are not being applied, but there is still room for discretion for the IECs to do it when they feel that it's warranted. As far as considering kind of the intended area where they seek employment, and forgive me if I'm misunderstanding this, but I think this to some extent ties into what David was suggesting and what the first public commenter was suggesting about, a contract that they will not go into a certain area or, commit themselves somehow to, limiting their future practice in a way that would, we can't, right now with the status quo, there's nothing that would really make that feasible or practical. It's a good kind of novel idea, but it doesn't fit the authority that exists. Currently, if you're talking about just a contract that they say that they, and this is nothing against the commenter. But if, we enter into a contract like that says, I'm not going to go into hospital work, I'm going to work in, this non-patient care area. So maybe the IEC will take that into consideration in crafting the requirements. We have no way of holding them to that contract if they breach it. And, again, this is not to part of our job is to kind of consider worst case scenarios. So unfortunately for the many participants who are out there and complying and doing the things they're supposed to do, they might understandably kind of balk at us looking at those worst case scenarios and dwelling on those. Allison's point last year and today is well taken, that there is a balance that needs to be reached. But we don't have currently any kind of mechanism to commit somebody to not go into a certain area of practice after they graduate from the program, for lack of a better word. The stipulations that we entered that we do have authority to enforce, those are stipulations in the context of APA adjudication. Our AGs will not prepare, based on statute, by the way, this is based on statute in the Administrative Procedures Act, they won't prepare a stipulation unless there is a pleading pending, which means an accusation has to have been filed, which is public and entirely kind of the opposite of intervention. So currently we don't have anything like that. And in order to do something like that, I don't even think we could do it by regs. We'd need legislation to create some different license type that authorizes a limited scope of practice or something like that. So coming back to your question, Nilu, I want to make sure I understood it correctly. You were talking about some way of considering the intended area in which they seek employment. And was I correct in kind of interpreting that maybe the terms of their recovery program might be tailored based on the fact that they don't intend to go into a certain area? Right now, we just don't have a mechanism to hold anyone to that.
However, there is that touch back with the IEC, to say that, okay, this person is working at this place, but the contract that we negotiated on was you're supposed to be working, in this intended area. So without getting into the concept of restricted practice, because we can't do that, right? We don't have restricted licenses.
We don't have restricted license, but
Right.
when they're in the intervention program, the IEC restricts their license. Right. While they're in the program, they say, no, you can't work. Yes, you can work, but you can't do patient care. Now I'm releasing you to patient care, and now I'm releasing you to patient care with access. So within the confines of the intervention program and their recovery agreement, we can restrict their practice areas while they're in the recovery program. However, when they're in the recovery program, the goal is to release them to a clear and unencumbered license that has no restrictions, right? That's what Uniform Standards 12 is about. As the IEC reviews their recovery, they review everything of their program and all of their ability to meet the check-ins and do their support groups, and what the feedback is coming from your CCMs and what the feedback's coming from your nursing support group facilitators. And if you are working, you get feedback from your worksite monitor. They take all of that into consideration and say, I think you can work in patient care, and they release them to it. It's not a requirement to work. They release them to having access to narcotics. It's not a requirement to work in narcotics. So that is something that is done while they're in intervention. So the understanding that I got from DCA and the other Healing Art boards is if that occurs 1 month in, well, that safe to practice has been determined. Now they need to ensure that the sobriety is maintained. So If the intervention committee has said that I'm comfortable with you working in patient care because I don't think you're going to cause harm, and I'm comfortable with you having narcotic access because I don't believe you're going to cause harm, as long as you have all of these things in place, we are testing you twice a week, you're meeting your check-ins, you're doing all of that, then what they're saying is you can practice safely. I need to make sure you stay sober.
Okay, right.
I need to make sure that you're still managing your mental health. And that is why you have to have that timeline of 3 to 5 years. So at the end of that sobriety for 3 to 5 years, and you have been released by your IEC to work in those areas, the understanding that I got from DCA and other healing art boards is that you've met Uniform Standard 12, number 4, even if you haven't worked, because you weren't in there for a practice issue. You weren't in there for a knowledge deficit issue. You weren't in there for, I don't know how to be a nurse, I need a refresher. You were in there because I have an addiction or a mental health issue. And so that is the part that's being monitored through this program. And so it would go against what that explained intention was to me if we even looked at where they would possibly work at in the future, because the idea is that through their intervention program, they've already been deemed safe to practice. Now, what you're ensuring that happened with Uniform Standard number 12 is that you're ensuring that because they've met all these requirements, that you believe they can be released to a full and unencumbered license, and that you do not believe they will relapse, that you can continue to practice safely once we graduate you from our program. That's the intent of that, is what I was told by DCA administration as well as other Healing Art Board executive officers. We are told that BRN may be interpreting that slightly different because we were looking at it as work focus. I need to make sure that you're safe to practice to work. Now, I don't know that affirmatively, because in the IECs, when I'm reviewing the stuff that is happening in the IECs and obviously receiving these letters, and that's why we look into it even further to say, okay, are we doing this? I'm not seeing that. What I'm seeing from the IECs is that they're taking everything into consideration, and they still have concerns with whether or not this person will be able to maintain their sobriety if they go back to work. And that is legit. That's a legit concern of our IEC committees. What I was told at that point, it's not about having them go back to work. It's about extending them in the intervention program to ensure that they are more firm in their sobriety. And so what can be done at that point is in the IEC committees is not you need to work, it's what do they need to show to you to demonstrate that they can practice safely. Give me a timeline, give me a process, give me what you want to see so that person can get there. Is that going to be that you are more truthful, you know, that you're not hiding things, that you are taking accountability, that you're not blaming others for what's going on, right? So when the IEC has identified these participants as, I believe they need to work and we need to monitor them, I believe what they're truly saying is, I don't believe that you're strong enough in your sobriety to work, right? So at that point, they need to address the sobriety more or the mental health issue more, not the you need to work more.
So
Right?
Lori, to encourage that thinking,
Yes.
which sounds like the IEC members are kind of leaning toward, and which I personally support, what would we need to do today to give the IEC direction, or to give you direction, you know, to share with the IEC about our focus in the intervention program is safeguarding sobriety?
I think this conversation was helpful. I think one kind of firm thing that would be helpful is to have a statement from the BRN that says, you guys do not believe that they must work in order to successfully complete, and that they are able to evaluate their process in the program, in their sobriety, to ensure that they're safe, even if they don't. Because what I'm hearing from IEC members is that they believe they have to show that they work in order to demonstrate that. And they want to do what our board wants.
Well, I would like to make that motion that you,
I think Yvonne has.
Go ahead.
Hand it really quick.
Share with you some of the statements that I've heard. I don't want to say all, because I can't say all, but many of our IEC members have stated that sobriety is one element of recovery, but if you are sober, that doesn't mean you're living in recovery.
Correct.
And so some of the participants, that's what they're trying to do, is to ensure that they're living in recovery and not just sober, because they are very two distinct issues. And then on the other one is those individuals that came into the intervention program because they had potentially diverted medication from a patient for self-use. Those are some of the situations that the IECs feel strong about, that we need to see them working in that situation.
Right, so-
Within the guardrails of the program. So if they need additional resources, the IEC is there. to
right,
help
so
them.
I don't want to prohibit an IEC from requiring work when it's demonstrated that that would be a significant step. But I do want to be on record that we're not, that we are not kind of insisting on work. And I agree with you, sobriety is different than recovery. So I would want to adopt the appropriate language for recovery.
And then one thing that I must address during that is what our public commenters said on that. And that is actually evidence-based. And I can pull up the articles and stuff if our board members want to read them and hear them and stuff, is that, yes, they may have diverted prior to coming into the program, but that is addiction-based. That is not a practice-related issue. That is an addiction-related issue. So if they're managing their addiction, whether they diverted prior to coming in, it shouldn't have no bearing on whether or not they require them to work, because there is no evidence that working supports sobriety. Having to work. There is many evidence out there that says getting them back to work as soon as possible in these supported environments helps them to gain sobriety and stay sober and work through that. But a work requirement, there is no evidence based, and that diverting of medications occurred because of their addiction, not because of their ability to practice safely as a nurse.
So Lori, could you help us with a statement from the board that we could turn into a motion and just gauge?
I would ask that we took a break.
Okay.
And that I would work with legal counsel to really kind of look at some language. And it would be beneficial to have a motion.
Okay.
Just a motion stating that our board does not have a requirement to work in order to successfully complete, but not eliminate that they could require them to work.
How long a
So,
break would you like?
I know that we were asking for I'm not supposed to say, but a bio break. So I would add that onto it and maybe ask for about a 15-minute.
So we'll take a 15-minute break and we will come back at 2:40.
Okay, 2:40, thank you.
Okay, welcome back, everybody. We're going to go ahead and take roll to establish a quorum. President Trujillo,
Present.
Vice President Patel,
Patel present.
Board Member Dominguez,
Dominguez, present.
Board Member Lawler,
Lawler present.
Board Member Cormack,
Cormac present.
Board Member Granowitz,
Granowitz present.
and Board Member Nguyen is present. So we left off with a discussion of a statement, maybe in the form of a motion from the board, for our EO to provide guidance to the IEC members on this topic. I'm turning it over to Reza right now to make a couple of comments, and then I think maybe we have fashioned a motion. So go ahead, Mr.
Yeah,
Pejrash.
thank you. This is Reza, BRN Counsel. So the idea was to indicate to our IECs that criteria 4 under Uniform Standard 12 doesn't necessarily require a work requirement. So some of what was kind of discussed offline and thought through was how do we go about ensuring that we're doing this correctly in consideration of the rulemaking requirements under the Administrative Procedures Act. So not to go too deep into the weeds, but just to give folks an understanding, currently we, under Uniform Standard 12, criteria for the language is that the participant must demonstrate that he or she is able to practice safely. That is effectively law. If we were to make any kind of a statement interpreting that law, either to say that it does require work or including if we were to make a statement interpreting that that does not require work, ultimately, either way, it would be a interpretation of that. And anytime that an agency wants to establish a formal interpretation of existing law, an interpretation would be considered a regulation. So that would trigger all of our requirements to go through the rulemaking process under the APA. That's a lengthy process, as you all know. Not that there's anything wrong with that, but you couldn't resolve it, today. The board certainly could, in the long run, pursue a regulation that interprets that criteria and is specific and prescriptive as you want to be. That's in the long run. But that hopefully helps to clarify my concern about offering a statement that interprets that criteria in some kind of an affirmative way. Having said that, I did touch on a little bit before what our current status quo is, and our current status quo is that that particular criteria is essentially interpreted on a case-by-case basis. And you heard Loretta speaking about how currently what's happening where where the requirement of working is being imposed, it's in situations where the IEC looked at that individual, they looked at their status in recovery and all of the factors, and they've determined in that individual situation that for them to be comfortable that that person can practice safely, they actually need to practice. But that work requirement is not being applied across the board, and where it is being applied, it is based on the IEC's own discretion and observations. So currently, the status quo is that we don't interpret criteria to necessarily require a work requirement. And I think that's kind of what the board was trying to put out there as the clarification, that we want it known that criteria doesn't necessarily require a work requirement. It can in the discretion of the IECs, but it's not a rule that it requires work. So that's what we currently have. So, and Loretta mentioned, I think, that she's been working with the IECs, and there is a push to do some training for our IEC members. So what I think is a possible thing that we could do today is essentially to ask our executive officer to continue doing what she is doing and explicitly ask her to provide guidance to the IECs on the application of criteria of Uniform Standard 12, specifically guidance that doesn't necessarily require work, that there are other ways that a participant can demonstrate that they're able to practice safely. By doing that, that information is provided to the IECs, and they'll hopefully use that as they continue to review these cases. However, at the same time, you're not violating the APA. B, the IECs still retain that discretion that they probably ought to have, that in situations that really, truly, in their view, necessitate it, they can do that work requirement. Any questions? Okay. So a possible motion that one could make is to direct the board's executive officer to work with the intervention evaluation committees to provide guidance on the application of Uniform Standard 12, including that criteria number 4 does not necessarily require that the participant work.
So moved.
I second.
Any questions or comments from, yes, please, Board Member Cormack.
Do we need to specify work as a nurse?
Oh, okay. Yes, we do.
We have no authority over any other employment that they may obtain or seek to obtain.
So it's implied.
Yeah.
I would
just
specify
want
it. It's a good point, Alice.
clear that, you know, some of them are finding other kinds of work to provide income while they cannot, if they are not currently working as a nurse. So
Good point. Good point. We will incorporate that into the statement. Thank you.
okay. Mr. Peshuhesh, if you could just read back the first part of the statement, because it seemed a little ambiguous, just the first part.
Sure. I won't be reading it because I didn't write it, but I'll do my best to restate it as closely as I did. So the possible motion is to direct the executive officer to work with the intervention evaluation committees and provide guidance on the application of Uniform Standard 12, including that criteria 4 doesn't necessarily involve a work requirement as an RN.
Okay.
A requirement of working as
Nor does it preclude a work requirement? I mean, I don't know how careful we want to be here.
Not limited to?
Yeah, I'm all in favor of being careful and precise. So let's try one more time. So you can type it up. Oh, I'll do my best. Direct the executive officer to work with the intervention evaluation committees to provide guidance on the application of Uniform Standard 12, including that criteria number 4 does not necessarily require working as an RN. However, that intervention evaluation committees do have discretion to impose such a requirement when they feel that the specific case warrants it.
Yes, that's right.
Thank you.
Okay, so Tricia, who had initially made the motion, is
Agreeing
in
with
agreement.
that statement.
And Nilu
And I second.
is also.
Okay, so what, so may I speak to the motion now, Chair Wynn?
Yes, please. Yes,
Great, okay.
please.
So something I had written down earlier, and I didn't use this word, and then I heard it in public comment, is autonomy. And so what I think this does is maintain the autonomy of the IEC to make the decision they feel is appropriate, but also give some autonomy to a licensee to choose to work, to choose not to work, and to choose the type of work. It's going to be a pun. I don't mean it, that works for them going forward in their recovery. So that's the spirit in which I'll be supporting this motion.
Thank you very much. Other comments from board members? Ms. Granowitz?
Nope, I'm good.
Okay, so because we did take a motion here, we're going to open this for public comment. So would the board moderator please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." BJH would like to make a comment. 1 second, please.
Okay, good afternoon. Hello, it's me again. I really enjoyed this discussion, this robust discussion you've all have had. It did bring up a question I have. I know we are saying that a participant does not have to return to work, does not have to have narcotic access, potentially does not have to work at all. But does their contract need to state that they can? Do they need to have those restrictions all lifted prior to being able to complete the program? For instance, I have not worked in patient care for years prior to even entering this program. I'm in my third year. When I was allowed to return to work, it was with restrictions, obviously, like everyone else. And I've never requested any of those restrictions be lifted because I have not needed them to. So I'm just wondering, when I get to the end of my 3 years, is that going to be a problem that my contract still says no patient care, no narcotic access, etc.? Thank you.
I can attempt to answer that. Everything is on a case-by-case basis, so I can't affirmatively say that would or would not be a problem. What you want to see is that the IEC releases them to full practice. Whether they choose to work in that manner at all, the IEC releases them to full practice. So that is typically done by the IEC when they feel that the evidence supports that the sobriety is maintained and the mental health is managed. So I would suggest potentially as an intervention participant that even though you don't need those restrictions removed, that if the way to get those restrictions removed is by requesting that to be removed, that would be something that you would do in advance of trying to complete.
Thank you for your comment. Nurse 117 would like to make a comment. 1 second, please.
Hello again, board members, and thank you for your time and moderator. So I know in the past with Maximus and the intervention program through them, a participant requested to enter the transition period, which was usually like the last year of their program, and the working restrictions were lifted. For example, like the participant could work full time or work overtime or work with patients in access. And Uniform Standards number 11 does kind of list a criteria that a licensee must meet in order to petition for return to practice on a full-time basis. But most of those requirements do involve like a positive worksite monitor, like evaluation of, I think, at least 2. And I guess that's where my question is, if a participant doesn't necessarily have to work in order to complete the program, based on the IEC's decision, I guess, is being in transition a requirement that we still have to, in the transition period, do we still have to meet that requirement in order to successfully complete the program, like at least being in that phase like a year prior to our 3rd year or our 5th year, whatever that is? That's my question, I guess.
Yeah, so the BRN effectively removed the term transition because that is not something that is supported in regulation, statute, or uniform standards. And so there is no transition period for BRN anymore. We do understand that there are some healing art boards underneath DCA that still continue to use that term, but that is not a term that BRN uses. So there is no requirement of transition. There is no requirement of being in transition for 1 year. What our IECs do want to see is that you are constantly progressing towards getting an unrestricted license and managing your sobriety or mental health issues while doing so. That when you look at Uniform Standards number 12, the requirement to work is not necessarily a barrier of completion if you're not able to do that, and that will be determined on a case-by-case basis.
I understand. So in order to, from what you're saying, Ms. Melby, is that in order to be successfully completed from the program, we do need to be fully released to, I guess, or be released to full practice before our like completion date in order to, if the IEC deems we don't have to necessarily work, but we have to be deemed safe to practice without any restrictions.
You definitely need to be deemed safe to practice. If you've got an evaluation where a provider has said that you're not safe to practice, it would not be something that the BRN could move forward on and say that we have ample evidence to release you to a full unrestricted license if you have a provider that's still saying that you're not safe to practice. So we definitely would want to see that your evaluation says that you are safe to practice. And we would like to see that your sobriety and all of the tools that you are using to support that sobriety show that you can be released to a full license that does not necessarily require that you work
Right.
or work full time.
Right.
So that is going to be evaluated on a case by case basis by the IEC.
Okay, but the IEC needs to, once that happens by a professional provider, the IEC has to deem that you are appropriate to be released to full practice before successfully completing, right?
Yes, because
Okay.
if the IEC has any determination or any hesitation where they would not want to release you to full practice, then there is something that is being demonstrated with your mental health or sobriety that says there's still some work you need to do to manage that recovery aspect.
Okay. Okay, thank you very much for the clarification.
You're welcome. It might be.
Thank you for your, nope, that's me. Thank you for your comment. Committee Chair, Board Member Nguyen, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Thank you very much. Okay, we have a motion in front of us. We'll go ahead and call roll on that motion. President Trujillo,
Yes.
Vice President Patel,
Yes.
Board Member Dominguez,
Dominguez, yes.
Board Member Lawler,
Yes.
Board Member Cormack,
Cormac, yes.
Board Member Granowitz,
But yes.
Board Member Nguyen, yes. That motion carries. So thank you very much, all of you, for your very helpful input. We're going to move on to item number 5.6, which is a discussion and possible action regarding the reestablishment of up to approximately 5 intervention evaluation committees and to meet the program needs and reassign current IEC members to newly reestablished IECs as appropriate. Lori? Oh, Yvonne, thank you. Yes, please.
Good afternoon. I'm Yvonne Leonard-Taps. I'm the Assistant Executive Officer. And at the January EIC, we had requested to reopen up to 5 intervention evaluation committees, and that was moved forward to the full board today. And the reason we would like to have up to 5 IECs is because right now we have some IECs that have, I think it's up to 27 participants.
Wow.
And some that have less. One of the things that we've heard from our IEC members is that 2-day meetings are very difficult. The prep work for seeing 19 to 25 participants is difficult. And so the thought is that if we had more IECs, because the participants do not have to attend in person, the IECs would be able to work more closely with the participants, and the review time would be more focused on a smaller number. We also want to be able to have more IECs throughout. Each IEC is scheduled to meet once per quarter, unless we call a special meeting. And we want to be able to have more meetings during that quarter for new applicants and or relapses and or anyone who's requesting to return to work for their initial time. We want to get them in front of the IEC as quickly as possible because that's their first time returning to work after joining the program. So we have established somewhat of a priority order for our IECs. Or for the participants to be seen by the IECs. We also would like the participants to be able to be seen by the IEC at least once per quarter. And with the current number of IECs we have, that is proving to be extremely challenging, at times impossible. We don't have, we would not open up 5 initially. We would start with probably 1 or 2 if approved, and then would like the flexibility to open up the other remaining ones as deemed necessary. The other thing with this request that we're making is we don't want to have an IEC that has 5 brand new people. So we would probably ask to move some of the IEC members to create these new positions. Currently, right now, we're only meeting in 2 locations in Northern California here at DCA. And then we have a location in Southern California that is at the dental board, so it's free of charge. And it's got parking. It's a very convenient place for all the IEC members from down south.
Thank you very much. Thank you very much. Questions or comments from board members on this? Go ahead, Ms. Cormack.
Thank you, Ms. Leonard Taps. There's a lot that makes sense here. I'm just thinking a little bit about unintended consequences. And one of the other balances we have to strike is making sure that whether it's us in a discipline or the IECs reviewing intervention programs have a wide enough, sort of scope, I guess I'll say, to see patterns and evaluate. I do understand that it's done on a case-by-case basis, but seeing trends, I just want to be sure that we've thought about how important is it for them to see sort of the full range versus this. I think I'm going to be in favor of this, but I just want to take a moment to think about any potential unintended consequences.
I do want to add that we had started in 2023 providing at least annual training that was delayed in 2024 with the transition to the new vendor. And so we do want to be able to meet with the IACs at least once, possibly even twice, because we know that some of the trainings that they may need is just the refresher on how to fill out their TECs, the more administrative training, and then we would like to have more of the substantive training. So to eliminate potentially unintended consequences and to help make the IACs across the board, we do want to implement training for all of them, even without the reestablishment of these up to 5.
Thank you very much. Yeah.
And I think one of the other suggestions that we had talked about earlier in the meeting was for potentially some high profile areas like completion or relapse evaluation, that in the formation of these new committees, we may form committees that specifically deal with all the relapses so that everyone that relapses and needs to go in for evaluation will go in front of an IEC that reviews all of the relapses so that they can see all those trends, so that they can see some of similar patterns and stuff. That we also had considered that potentially a IEC does all of the completions or all of the admissions. And so that is something that we will continue to work with internally to see what that looks like and if that is feasible. And if that's something we get positive feedback from current IECs and such, then that might be something that we move forward with so that we can help to work with those items that need to be as consistent as possible.
Okay, that's super helpful. Thanks for letting us all know that you're thinking about those, dimensions of it. Thank you.
Great. Yeah, hearing no other comments, I think we're ready for a motion.
David Lawler here. I move to reestablish up to 5 IECs.
And I'll second it. When? Let's go out to public comment on this motion. Thank you.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." BJH would like to make a comment. 1 second, please.
Hello again. Something that's come up several times in my nurse support group is in the essence of wanting things to be done quickly and more efficiently with the IEC committee meetings. Why can't, even best case scenario, if you're able to see your IEC quarterly, for completion instances, your completion sobriety date might fall in between quarters. So say you have your IEC in January, your 3 years in February, you are still waiting and paying for tests till April, maybe the end of April. So the question was, and someone who knew someone in the program years and years ago said it used to be that you could request completion to exit the program during, say, your January meeting, and then the IEC would write something saying completion of program has been granted pending 100% compliance up to program sobriety date. So just wondering if that is even an option, because it seems like it would save a lot of time, money, and resources on both the IEC and the participants' part when it comes to those completions. Thank you.
Thank you for your comment.
Okay.
Nurse 117 would like to make a comment. 1 second, please.
Hello again, board members, and thank you so much for your time, and moderator for your time. When I originally joined the intervention program almost 2 years ago, I was told that I would be seen by my IEC every 3 months, but unfortunately that has not been the case for me. Myself and other participants in my nurse support group are told we have to wait 6 months to be seen by our assigned IEC, and of course this causes extreme hardship to not have answers regarding our work and program status for half a year. And it just feels like our lives and careers are being put on hold. Being able to be seen by the IEC quarterly, as outlined in the program, would be extremely beneficial. And I know these things don't happen overnight, but when can the participants expect to see the new IEC groups and quarterly schedule in effect? Thank you.
So I don't know that we will be able to maintain a quarterly schedule. I think the one thing that I do want to point out is Premier in your CCM is going to be your point of contact. If you have questions about your program, if you have questions about your recovery agreement, if you have got questions about anything, you are supposed to be reaching out to them, and that is going to be your point of contact in between any of the IECs. The IECs are solely there to evaluate your progress in your program. They would make recommendations to your program if there were things that they identified that they need to address. So your day-to-day contact is your CCM with Premier, and that should be someone that you can contact within 24 hours. That is something that's in our contract that has a 24-hour response time for the CCMs. So you should be able to get all of those questions clarified. If, like the example that the person brought up in public comment right before you, where their sobriety, 3-year sobriety date is February 18th, and there's not an IEC meeting until April, that is definitely a potential hardship. And so at that point, we could look into seeing that the IEC that is scheduled right before your sobriety date could make a preemptive decision that says pending completion of everything, maintaining your sobriety, et cetera, that you then could complete, because it's not the IEC that actually does your processing of paperwork and completing you. That is also done through your CCM at Premier that would then send it over to our program manager. And then we would then evaluate at that point. So there are possibilities that we can implement things to streamline up to and including a possible visit to the IEC that happens within about a month of your sobriety date, if it would have delayed you, a month or so into having to still test and do that kind of stuff, because we do know that there is definitely a financial impact to that. But your day-to-day communication on, I have questions about my program, they need to go to your CCM and they need to be answered by your CCM. If you are not getting answers, please let us know so that we can work with your CCM to ensure that this is something that is being done. We want to make sure that that communication stays a priority.
Thank you for your comment. Committee Chair, Board Member Nguyen, there are no other public requests for comments on the WebEx. Do we have any in-person requests for comments there in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Thank you very much. Okay, we'll go ahead and take a roll call on Mr. Lawler's motion. President Trujillo?
Yes.
Vice President Patel?
Patel, yes.
Board Member Dominguez?
Dominguez, yes.
Board Member Lawler?
Lawler, yes.
Board Member Cormack?
Cormac, yes.
Board Member Granowitz?
Which, yes.
Board Member Nguyen? Yes, that motion carries. We are on our last item. Item number 5.7, and this is regarding the Intervention Subcommittee Charter. So you'll all remember that we created a subcommittee in our last board meeting. Consists of Vice President Patel and myself. We will be interviewing potential members to the IEC committees from now on, and there is a charter in your program material. And Lori, is there anything else, or Yvonne, is there anything else you'd like to say about this before we entertain a motion?
No, except for we do have applications that we would be able to advance to the subcommittee if this charter was approved.
Thank you. Thank you. Any questions or comments from board members? Okay, hearing none, I will go ahead and make the motion to adopt the Intervention Program Subcommittee Charter. Is there a second?
I'll second.
Okay,
Lawler.
second by Mr. Lawler. We need to go out to public comment on this item. Would the board moderator please take us to public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board Member Committee Chair Nguyen, there are no other public requests for comments on the WebEx. Do we have any in-person requests for comments there in your location?
No, we do not.
Thank you. Would you like me to close this window?
Yes, please. Thank you very much. We'll go ahead and take this to a vote. President Trujillo,
Trujillo, yes.
Vice President Patel,
Patel, yes.
Board Member Dominguez,
Dominguez, yes.
Board Member Lawler,
Lawler, yes.
Board Member Cormac,
Cormac, yes.
Board Member Granowitz,
Granowitz, yes.
Board Member Nguyen, yes. That motion carries, and we are done with this portion of the agenda. I'm turning it back over to Lori.
We're done with the board meeting. Board President, do you want to adjourn us, please?
At this time, we will adjourn the board meeting for today, and thank you all for participating with us, and have a wonderful evening.
Woo-hoo!
Well done. Good job.